May I please?
Yes.
My lord, I beg to mention for listing of a matter, my lord. This is for withdrawal, my lord. For withdrawal, my lord.
Okay.
Tomorrow, my lord.
Yes.
All right.
May I please, Lord?
Yes.
My lord, I beg to mention for listing admission matter, my lord. My lord, answer is please, my lord, please.
Admission matter, please inform the registry. Approach the registry.
22nd, my lord.
Approach the registry.
My lord, similar pair, but my
You also.
pensionary benefit, my lord.
Maybe, but you inform the registry.
My lord, if
Take it up with the registry, okay?
the
Next.
next week, any day, my lord.
No, no. Next.
May I please, your lordship, I beg to mention item number.
Why have you tied up your gown like that? Is it going to fall off? Yes.
Lordship, I beg to mention item number 20, lordship,
20. Yes.
for adjournment, lordship.
Adjournment. Why do you want adjournment?
Lordship, due to some personal difficulties of my senior
You are for the petitioner.
petitioner.
Okay, as paid for by on behalf of Mr. G. Jalan, Learned Counsel, for the petitioner. Matter stands adjourned to be listed again after 2 weeks.
Your Lordship, I beg to mention item number 12 for the adjournment for the next week, 24.
Why do you want adjournment?
Due to personal inconvenience,
Who is inconvenient?
yes, senior,
Who is the senior? What is the senior? Okay, Mr. R. Goswami, Learned Counsel for the petitioner, is said to have some personal difficulty to appear before the court today. On a prayer made on his behalf, let the matter be listed again after a week.
May I please, your lordship, therefore listing a fresh motion matter we have filed on before vacation, lordship, matter may be listed on
Hmm?
after tomorrow. Fresh motion matter.
Fresh motion matter. Any urgency?
Urgency
come
is
by-
there, lordship. Day after tomorrow.
When did you list it? I mean, file it
Before vacation, lordship, on 25.
before vacation.
Before vacation.
All right.
Please, lordship, I beg to mention for listing, lordship, family pension matter, lordship.
Hmm?
Family pension matter, lordship. Family pension.
Family pension matter. Motion. If it's not motion, please approach the registry. Okay.
Admission.
Yes.
May I please, Lordship, I beg to mention item number 21, Lordship. 21. Lordship, today engaged counsel Mr. L.R. Mazumdar, he has some personal difficult, Lordship.
When do you want it? After a week? After a week, huh? Let's say order.
May I please, your lordship. Lordship,
L.R.
I'd like to
Majumdar.
withdraw item number 7, my lord. There has been certain clerical error. The liberty to file a fresh. Item number 7, man.
I'm preparing for secondary education.
Any objection?
No, your lordship.
Okay. Ms. M. Sharma, Mr. M. Sharma, Learned Counsel for the petitioner submits that there are some clerical error in the writ petition, and therefore he may be allowed to withdraw the writ petition with liberty to file afresh. Ms. P. Das, Learned Standing Counsel, Secondary Education, has no objection. In view of above, the matter stands disposed of as withdrawn with liberty to file afresh, if so advised.
May it please your lordship. Lordship, I beg to mention for listing a writ petition for admission, lordship, next week, any day, lordship. No interim order is there, lordship.
Huh?
A writ petition for admission, lordship, next week, lordship.
You approach the registry.
Lordship, for admission, lordship.
I know,
No interim order is there, lordship.
and then maybe you approach the registry.
Lordship.
Hmm.
Oblige your lordship.
My please, your lordship. Lordship, I pray for listing a contempt case, your lordship, for next week, your lordship, any date, your lordship. Since January of 2021, not listed, your lordship.
You also please approach the
Last date
registry.
of listing 11 December 2020.
You also please approach the registry.
For orders, your lordship.
Approach the registry.
May I please your lordship. Your lordship, I beg to
Oblige.
mention item number 3, your lordship.
Item 3.
Yes, lordship, that matter may be adjourned for the day only, your lordship.
Why? Why do you want adjournment?
Lordship, the council engaged in this case, your lordship, out of station.
Who is the counsel?
And Mr. M. Ahmed, your lordship.
Mr. M. Ahmed, Learned Counsel for the petition is said to be out of station. On a prayer made on his behalf, matter stands adjourned for the day.
May I please, your lordship. Lordship, I beg to mention item 26, lordship. 26. Item 26, lordship.
Yes, what do you want?
Lordship, I may be allowed to file, reply, lordship. Affidavit filed by the respondent, age, lordship.
Your good name?
MS, lordship.
MS Alam.
MS.
Okay. As paid for by Mr. MS Alam, Learned Counsel for the petitioners. How much time?
2 weeks, lordship.
2 weeks time is granted. File the under affidavit. To the affidavit in the position filed by the respondents. Okay.
Wait, please, Lordship. Well, this is regarding pensionary benefits, Millards. We have received at 27 lakhs 43,669. Now, whether this, what are the amounts we have received, Millard, we do not have any idea. So 1/28 to 2025, we received 70 lakhs 92,551. On the same date also, we get 8 lakh 26,192. Thereafter, that is so far 1,19,6 to 25. We received 1,24,926, totaling below 27 lakhs 43,669. Now, whether we have to get, see, on the last, the 1,24,000, that is a GIS, General Insurance, is GIS, no? It is GIS. Now, whether this is PF or what, we do not know. Now, what are the amounts that have been credited to our account, Milord? We do not have any, well, they will explain that.
Your Lordship, on the last occasion, Your Lordship, there is a direction, Your Lordship, towards the petitioner to approach to the inspectors along with documents for the verification of documents. And that part, Your Lordship, petitioner is there to Your Lordship to give the proper instruction, Your Lordship, whether she approached it or not, Your Lordship.
We approach,
Approach whom?
we
Inspector of the
inspector
school,
of the schools. We approach, Milord.
Mongoldo.
We have already approached as per the directions, Milord. And documents are all submitted before them.
Your Lordship, a short date may be given, Your Lordship will obtain instruction for the process, Your Lordship, verification of documentation, Your Lordship.
Please write, the presented petition has been filed by the petitioner seeking release of the dues of his late wife, who was working as
As headmasters, Milord.
headmistress.
Yeah, Milord. In the school, in Milord, Dahi Higher Secondary School, principal, Dahi Higher Secondary School, Milord.
In Dahi Higher Secondary School, Mongoldoy. To stop, although some amount has been released since the filing of the writ petition,
Milord.
but the learned counsel for the petitioner submits that the petitioner is not aware as to whether the entire amount has been given or balance remains. Stop, in this connection, the petitioner was required to meet the respondent number 3, that is Inspector of Schools, Darang District Circle, Mongoldoy, with all the requisite documents. Stop, the learned counsel for the petitioner submits that the respondent number 3 has since been approached with the documents. Stop. Ms. P. Das, learned standing counsel, secondary education, submits that she may be given some time to obtain necessary instructions in this regard. In view of above, let the matter be listed again after 2 weeks. 2 weeks?
Yes, sir.
All right.
I'm deeply obliged.
Wait, please, your last.
Yes.
My lord, before my respected senior starts, my lord, well, I need some time in this matter, my lord, because in this case, my lord, what had happened, in the month of November 2024, this matter was heard, my lord, and matter was
When? November?
November 2021, matter was CAB, my lord.
November 21.
24, my lord.
Oh, okay.
Thereafter, although this matter was, matter came on August 2025, my lord, in this matter, records were called for, my lord, and I have just got to know when I inspected the file, record is, my lord, with the court, actually, my lord. The record is tagged with the file, my lord, court file.
Report is there?
Yes, my lord.
Okay.
So,
So,
my lord, for hearing, my lord, actually, it was argued at very long time, my lord. Now, my lord, we have to go through the records once.
you want to
And-
see the record and argue again?
Yes, my lord. Kindly a date may be fixed, my lord. A
Okay.
short date will also do.
Mr. Chaudhary, can we,
Next Wednesday, Miller.
Wednesday?
Because when it's a very long pending, Miller, meter was made CAB, thereafter it was released.
Okay, what is the matter regarding?
Well, the matter is very simple. Now my services was provincialized as a principal of a college. Now there is some doubt of the authority regarding my PhD degree. Now, my lord, the government of Assam wrote to the university from which I obtained the PhD degree, and that university said, no, the degree is okay. And thereafter, my lord, government of Assam also constituted a committee to look into the PhD degrees obtained by different incumbents, my lord.
Mhm.
Then government of Assam came to the conclusion that in respect of 3 universities, there are doubt.
Mm.
The Magad University from which the petitioner obtained the PhD degree, in respect of that, my lord, there is no, doubt.
There's no doubt.
Yes.
And despite
Now,
that,
but now, because of that, my lord, the disciplinary proceeding has been initiated against me. I was suspended.
Mm.
Then, my lord, I was reinstated pursuant to an order of this honorable court. Then, my lord, 3 charge sheet has been filed. What is this, my lord? What is the misconduct?
you're still serving?
Yes, yes.
You're still serving?
Full cop, yes.
Okay, okay. All right, we'll hear the matter.
Yes.
Then,
It's a very simple matter, my lord. Let my learned friend refresh his memory, there's no problem.
you'll be arguing the case.
Now, K.
Who-
Gogoi will argue, my lord.
K.
and he will be
Gogoi.
Playing to, my lord, for records, my lord, records which is.
The
No, that will give you. When can we have the matter?
Thursday
My lord,
morning.
next week, my lord, next week,
Or let it be on Thursday, my lord, next Thursday. Today is Monday.
Thursday is what, 24th?
Yes.
Okay. Mr. Ken Chaudhary, Learned Senior Counsel, appears for the petitioner, while Mr. S. Das, Learned Standing Counsel,
higher education.
Higher Education, appears for the respondents. Who is,
on
16.
along with Miss
on behalf of each of us.
K. Borbochari, Learned Counsel, who represents respondent number 5. 5 or 4?
Next week or
That's one number 4.
next week or tour বন্ধ হয়ে আছে নাই?
Next para.
22 days.
It is submitted at the bar that the matter was heard at length and reserved for judgment. But
16 আছে
the
কিন্তু,
final decision has not been made. And therefore, the matter has to be reheard. Some Mr. S. Das, Learned Standing Counsel, submits that he may be returned the records so that he can prepare the matter for argument. Sub registries, they shall therefore return the records which were submitted to the court earlier to Mr. S. Das during the course of the day by obtaining his acknowledgement. And let the matter be listed for,
16th, my lord.
this will be what, for admission or
Actually, it was at this stage of motion, my lord.
Turn on.
Still, it is at this stage of motion. Or it can come as a motion, may come Friday also.
let it come on 23rd as you suggested. I
Okay.
think then we let it be listed on 23rd
Okay.
as agreed to by the parties. 23rd means 23rd October.
Deeply.
Mr. Das, you take the records and you will again produce the records on
Yes,
that
yes,
day, okay?
turn on.
Not that you don't come with the records.
No, no, no.
May I please? Page number 11 is the my lord, just operative contempt. Notice may be issued.
What are you saying?
Operative portion, page 11, my lord.
What was the direction?
It's a direction for disposal of the representation, my lord, with regard to.
Oh, representation not yet disposed.
Yes, not disposed. Yes, that's.
Where's your representation? Page 12.
Page 12.
Okay, please write hard Mr. B. Prokasta, Learned Counsel for the petitioner, who submits that the order dated 24/6/2025. passed by this court in WPC number 3534 of 2025 has not been complied with by the respondent despite respondents, is it? Yes, respondents. Despite copy of the same having been furnished to them. In view of above, we issue notice to respondent number 1 only at this stage.
My lord, 2, 3, because my lord, page number 13, your lordship will find, respond number, 1 has communicated with the, 2, 3, they have not, further processed.
Hmm?
Page number 13, your lordship will find, and the respond number 1 has communicated with the respond number 2 and 3 of his, my lord. They have-
Okay, so issue notice to the respondents returnable by 4 weeks. Petitioner to take steps for service of notice upon the respondents by registered post with ADU within 3 days.
Obliged.
Hey, please, your lordship, I'm standing here on the behalf of my senior counsel, Mr. A.K. Bhuya, who has been recently appointed as the senior standing counsel for BTC. As we have no availability of documents with us, we request the court to list the matter in the next weeks.
F. Bhuya.
Yes.
My lord, in this petition, our prayer is very limited. Only impletement we are praying, my lord. So after the, my lord, Commissioner National Education Society for tribal students, we are praying for implement. My lord, they are a necessary party. So, my lord, after implement, we can, my lord, furnish copies to my learned friend also, my lord. BTC ko na sila.
Whom do you want to implead?
My lord, if my lord may be pleased to turn to page number 9 of my IA, my lord. It is the respondent number 17 or the opposite party number 17 in this interlocutory application, my lord. We are praying for implement of the same opposite party as a respondent number 17 in the main writ petition, my lord.
Commissioner National Education.
National Education Society for the tribal students, my lord. The necessary party, my lord.
How are they a necessary party?
My lord, they are necessary party.
How are they a necessary party?
My lord,
This society, my lord, they are the one who is the custodian, my lord, everything of this Ekaluva Model School. Like Kendriya Vidyalaya Sangathan. Is this, my lord, this Ekaluva Model School, these are for tribal students. my lord.
public is a
And
necessary.
Mr. Dhar, you are appearing for
I am
whom?
appearing for 5.
The application is by Mr.
My lord,
Bhuya.
my lord.
You are supporting his application.
My lord,
Yes, sir.
है ना?
because I know, my lord,
Okay.
they are an.
So let me ask him, it is his application.
My lord.
I'm asking him and you're answering for him. You are for some of the respondents, I know.
Lord, what has happened, my lord? This is a society, my lord, which is regulating the affairs of, my lord, these my schools, my lord, scattered in the all over the country, my lord.
What
This-
is the relief you are seeking in the writ
My lord, the
petition?
relief we are seeking, my lord, is if my lord, to ensure the functioning of the school as well as, my lord, some food, this is a residential school, my lord. This is,
Functioning of?
my lord, what has happened, my lord, there is a disturbance of the functioning by the district administration, my
Ah.
lord. So it has not been allowed to properly function, saying that we are not been validly constituted committee. So therefore, we do not have the locus to manage the affairs of the schools, my lord. Now, my lord, in this writ petition, my lord, we have prayed, my lord, that at least the schools, the students which are being, my lord, they are residing therein in the, my lord, hostels, they should be provided with the food and other reliefs, my lord. Now, my lord, as this, my learned friend, My lord, the district committee which has been, is required to be taken up these categories of schools, my lord. Accordingly, this school has also been taken up by the district committee of the concerned district, my lord. But even then, my lord, thereafter the food items which are required to be supplied has not been provided to the students, my lord. So therefore, we are praying, my lord, that the at least this minimum arrangement for the supply of the food items for the survival of the students should be there. Now, my lord, when this petition was moved on the very first motion day, my lord, objection has been raised from my learned senior friend, my lord, that it is a necessary party, my lord, this instead this body, my lord, which we are now praying. So therefore, my lord, this interlocutory application is today, my lord. And my lord, we have also gone through, my lord, that this is a necessary, the body is a necessary party, my lord.
See, your prayer in the writ petition
My
is
lord,
to ensure full-fledged functioning of Eclavia Model Residential School.
correct, my lord.
Then to direct the respondent to take EMRS.
My lord.
Means, what is EMRS?
Ecologbo Model Residential School, Dolbari, my lord.
Full-fledgedly.
My lord.
Then regular funds. These
For
are the things.
functioning, yes, my lord.
So now, in all these issues, the Commissioner National Education for Society for Tribal
Yes,
Students
yes, tribal
is
student
necessary.
required, my lord, because these schools are meant for the tribal students, my lord.
I see.
My lord, in the
Eclavia School.
my lord, 6th schedule area school, my lord.
Okay. So we'll allow the
My
application
lord,
then.
my lord.
Let us simply. Huh?
Hey, apo,
One. So why not one more commissioner also?
No, no, Ministry of Tribal Affairs is a different union body, my lord, but this society is a different entity, my lord.
Ministry is there, no doubt, but this is a society again,
My lord.
National Education Society. Let it be a party. You also may also
Well.
appear ultimately. Third, Mr. A.R. Bhuyan, learned counsel for the applicant who submits that by filing this application. The applicants seek implement of the Commissioner, National Education Society for Tribal Students as party respondent number 17
17.
in the connected writ petition. Since their implement is necessary for effective adjudication of the writ petition. Mr. Ardhar, learned counsel appearing for
5, 6, 7, 8, 9, 10, 11.
respondent numbers 5, 6, 8, 9, 10, and 11. That is Department of Tribal Affairs,
My lord.
bracket plain. As well as Miss, your good name? P. Kashyap, representing the
BTC.
BTC respondent, and Miss K. Fukan. Appearing for respondent numbers 1, 2, and 3, that is Ministry of Tribal Affairs, Government of India. Okay. 1 to 4 then. I have no objection to the prayer made by the applicants. In view of above, after full stop, in view of above, implement of the Commissioner National Education Society for Tribal Students is allowed to be implemented as respondent number 17. IA stands disposed of as allowed. Next para, in view of, in the next order, in the writ petition, in view of the order passed today
Well.
in IAC number 2982 of 2025, the petitioners shall file amended cost title in 2 sets before the registry. Incorporating respondent number 17. Next para. Let notice be issued to the newly implemented respondent number 17, returnable by 4 weeks. Petitioners to take steps within 1 week for service of notice upon respondent number 17 by registered post with ADD.
My lord is issuing notice in the main writ, my lord.
Yes, on 17.
On 17. My lord, in the main writ, notice has not yet been issued, my lord. Earlier also notice has not been issued.
Oh, not yet issued.
No, my lord. So, my lord, may I pray, my lord, after this necessary correction, can it be taken up on next week, any date, my lord?
Okay, then you cancel that part. But after registry shall do the needful, no? Full stop. List the matter again after a week in the motion column.
My lord, some urgency is there, food items has been holding up. So can it be on next week, Friday, my lord?
My lord.
No, no.
Now you have
I
objection.
am not asking, I am not asking.
Serious objection I have. I have.
No, no, my lord, with all respect to my learned senior friend, my lord, he can object. Today I am not praying for any interim order.
No,
I am only asking for a date only, my lord.
we'll not fix a date. Let the
Fine.
registry fix a date. List the matter again after a week on a date to be fixed by the registry.
My lord. Oblige me.
May I please? This item is connected with my lord, item number 36.
Huh?
Item number
36.
36 may also be taken up, my lord. But in this case, my lord, as per last
On
occasion,
last
my-
occasion, I was directed to take instruction lawsuit. So I have submitted that the PH certificate. The petitioner has obtained the PH certificate from the Sodhuri Saran Singh University, Meerut, Uttar Pradesh lawsuit. So there's some doubt created on regarding his lawsuit, that certificate. So accordingly, we have sent a request to the authority of the Sodhuri Saran Singh University, Meerut, for verification of genuineness of the degrees lawsuit.
What is the degree? Which degree?
B.Ed degree, my lord.
B.Ed.
B.Ed degree.
B.Ed.
B.Ed degree. Now we're waiting that verification process.
When did you ask for the information?
On 27/9/25, we have written the letter to the
27/9.
9 years ago.
To whom?
To the authority at the Sodhuri Saran Singh University, Meerut, Uttar Pradesh lawsuit.
So
So
they are,
Chaudhary Saran Singh
are they a
University-
party here?
No.
No.
They are not a party.
Then, okay,
At the verification test, we have found that his
Oh.
certificate was supposed to be lawsuit, a little doubtful lawsuit.
so what about this item number 36?
In partition,
Same
my lord,
petitioner.
issue is something different, my lord. I will explain.
Petition is the same.
No, petitioner
Oh.
issue is different lawsuits.
Issue is different.
Then
but
why you say it's connected with this?
It's connected to the same selection process. It's connected with same selection.
Same selection process, but the issues regarding your B.Ed certificate
Here is no, here,
clarifications required in item number
here number
6.
it
But
is-
in item 36, anything like that?
it's for sports certificate.
Hmm?
It's certificates with regard to sports.
Sports.
Yes.
That was regarding sports
Sports.
certificate. So we're waiting some.
This is regarding B.Ed.
This is regarding B.Ed.
And both are from Chaudhary Charan Singh.
No.
No.
Certificate?
So
No.
sports certificates are from the local authorities, ma'am.
Okay. Only that selection process is the same.
Yes.
Sir, why do you connect that together? You can take it separately.
Yes, no.
Item 30.
It's listed separately also.
Okay, no problem.
I thought we could
Here-
combine it just like that.
Yeah.
Now, you want some time?
Yeah, I need some time.
How much time should you require?
At least 2 weeks time lawsuit.
If you have written on 15th of September,
No, 27th of September.
I'm sorry, 27th of September. So, in October.
It will take some time lawsuit. It will depend upon the response they give.
It will go to Uttar Pradesh. Then it will come, it will take.
End of this month or
End of
Yes,
the-
sir.
Mr. B. Prokasta, Learned Counsel appears for the petitioner. While Mr. SMT Chisti, Learned Standing Counsel, Secondary Education, appears for respondent numbers 1, 2, and 4, and submits that a letter has been written to the authorities in Chaudhary Charan Singh University, Meerut, on 27/9/2025.
Take a view. Oh, take a view.
It will go to Uttar Pradesh.
While Mr. SMT Chisti, Learned Standing Counsel, Secondary Education, appears for respondent numbers 1, 2, and 4, and submits that a letter has been written to the authorities in Chaudhary Charan Singh University, Meerut, on 27/9/2025. seeking clarification regarding the Bachelor's of Education degree obtained by the petitioner. Stop.
BA and BEd both certificate from university law, BA and BEd.
Bachelor's of Education as well as the Bachelor of Arts certificate as well. So he therefore submits that pending the information / clarification to be received from the said university. Matter may be adjourned. You are there also. Miss P. Devi appears for respondent number 5. And Miss Fukan appears for respondent number 3. Considering the submission made, let the matter be listed again after. Okay, we'll list.
3rd of
Listed
November.
on 3rd of November.
Yes.
3rd of November.
Obliged.
Right, please, your lordship, matter pertains to compassionate appointment lordship. Petitioner approves earlier lordship, page 21 lordship. Relevant page 23, para 3.
Then
Thereafter, lordship, DLC recommended lordship, page 32. Relevant page 33 lordship.
Compassionate.
Page 32, inspector of school lordship, second para. Serial number 2.
what is your name? Pallavi.
Lordship, Pallavi Setri,
Pallavi.
Pallavi Devi
That
Setri.
is the petitioner.
Yes, lordship.
So the remarks is blank.
Before table lordship,
Before table or after table?
before table lordship, the district level committee. Last 3-4 line recommendation lordship.
Yes, then what is the issue now?
Lordship,
After that, what happened?
thereafter lordship, the inspector of school lordship forwarded the DLC minors lordship, page 36 lordship. To the secretary, Govt of Assam Department of School Education lordship, page 36. Thereafter, OM has come lordship.
OMS coming means which year? Which was the date?
89 lordship, 89 2024 lordship. Annexure 5 lordship.
Did you submit your application?
Yes, lordship. On 11, 15/9 lordship.
What was the last date?
Last day, lordship.
On the last date you submitted?
Yes, lordship. I have filed this writ petition on 11/9 lordship.
Ms. Das, you're there? What do you say?
Here, your lordship, the review was done, your lordship, and as per your lordship, annexure 5, page 37 onwards. It was clearly given, your lordship, the last 3 lines, your lordship. It starts from such a delayed appointment. Last 3 lines, your lordship. Such a delayed appointment. I would like to read it, your lordship. Such a delayed appointment would also amount to treating a claim for compassionate appointment as though it were a matter of inheritance based on the line of succession. Appointment on compassionate should not be a source of recruitment. Continuation, page 38, means for the family to tide over the sudden financial distress. The Honorable Supreme Court also in a number of cases has held that granting compassionate appointment after a lapse of considerable time after the death of a government employee would not be furtherance of the object of a scheme of compassionate appointment. And your lordship, pertaining to that, your lordship, judgment is also placed, your lordship, passed by the Honorable Supreme Court Civil Appeal number 8842 8855 of 2022 in the case of State of West Bengal versus Debabrata Tiwari and others. The Honorable Apex Court has observed that the application for appointment on compassionate grounds shall have no redeeming purpose to be considered and decided several years after they were filed in the connection, para 7.5. This is the aforesaid judgment dated on 3/3/2023 is produced herein below. And this is the, your lordship, 7.5.
All right, I'll record your submission. We'll
There is a delay, your lordship.
dispose of the matter. Your good name?
And Hussain.
Heard Mr. N. Hussain, learned counsel for the petitioner. And also Ms. P. Das, learned standing counsel, secondary education. Stop. Having regard to the nature of the case, the writ petition is taken up for disposal at the motion stage itself. Stop. Next para. This is the second time the petitioner is before this court. Stop. The first writ petition being WPC number 5257 of 2023 was disposed of in white order dated 13/9/2023. By interfering with the decision of the respondent authorities, who found the application of the petitioner to be time barred for seeking compassionate appointment. Stop. The matter was therefore referred back to the district level committee (bracket DLC) Sonitpur for fresh consideration in accordance with law. Next para. As directed, comma, the DLC Sonitpur held in its meeting held on 8/12/2023 considered the case of the petitioner once again and decided to recommend the case of the petitioner for appointment on compassionate basis in either grade 3 or grade 4 post by placing by referring the matter to the state level committee. bracket SLC. Stop. The minutes of the meeting was thereafter forwarded to the secretary to the government of Assam, Department of School Education on 27/5/2024. But despite the same, the case of the petitioner has not been considered by the SLC. Stop. The learned counsel for the petitioner submits that the state government in the personnel B department have come up with an office memorandum by which the appointment on compassionate basis has been stopped in view of the introduction of the compassionate family pension scheme. Stop. The learned counsel therefore submits that, but it is due to the office memorandum it is perhaps due to the office memorandum that the case of the petition has been rejected, has not been considered by the SLC. Stop. He, however, submits that similarly situated persons aggrieved with the office memorandum had approached this court and all the writ petitions were disposed of by a common order. Dated 3/4/2025. And WPC number 342 of 2025 being the lead case. By directing the respondent authorities to consider all pending applications for compassionate appointment in terms of the relevant scheme of the state. To stop pursuant thereto, a notice had been issued by the Personnel B department on
38,
38/2025.
2025.
38/2025 requiring all such applicants seeking compassionate appointment to submit their requisite documents before the authority concerned on or before 15/9/2025. Stop. The petitioner has also submitted her documents for consideration. Stop. The learned counsel therefore submits that the respondent authorities may be directed to consider the case of the petitioner for compassionate appointment. Next para, Ms. P. Das, learned standing counsel, secondary education. has drawn the attention of this court to the office memorandum dated 18/9/2024 and submits that in a case of compassionate appointment, the basic idea behind is to give relief to the family of the deceased government servant at the earliest. And that such relief cannot be expected to be given after a lapse of several years, such as in the instant case. She submits that the Honorable Apex Court had clearly made an observation in this regard in Civil Appeal number 8842-8855 of 2022. In the case of State of West Bengal versus Debabrata Tiwari and others. Stop. Such being the position, the learned standing council submits that no relief can be given to the petitioner at this stage for want of immediacy. Next para. Having considered the submissions made by the learned councils for the rival parties and on perusal of the materials available on record, we have seen that the petitioner had earlier secured an order of this court on 13/9/2023 in WPC number 5257 of 2023, wherein a direction was given for reconsideration of the case of the petitioner by the DLC concerned. So not only the DLC had made its consideration same to the state government, and for which you cancelled, and that the same has not been questioned by the respondent authorities by filing necessary process. Stop considering the same and also taking into account the fact that the petitioner had also submitted our documents on 15/9/2025 before the Secretary to the Government of Assam, Personal B Department. The writ petition is disposed of by directing the respondents to place the case of the petitioner before the next SLC for consideration in terms of the relevant guidelines.
Like to add one thing, Your Lordship, in the Debabrata Tiwari case, Your Lordship, there is specifically, it has mentioned that that it is again made clear that this order cannot be used as a precedent for case that filed on 4/4/2025 and thereafter. It shall only apply to cases that are pending before this court as on dated 3/4/2025.
From where are you reading that?
There is similar.
In notifications applicable only for cases, those cases who have filed their application on within 3/4/2025.
So from where are you saying that?
It is item number 10 in hospital.
He has not annexed that new notification. होगा ना. He has not annexed the notification, new notifications in the present with petition.
Petition.
देखो नंबर.
Case number 43.
Oh, which page? Which petition?
That petition that's now I think.
This one,
Yes,
page 43.
yes, Your Honor. Paragraph number 7, last.
No, see, apart from this, I think there's another order also, by which it was also held that it cannot be restricted to that case only. There's another order also I've come across.
Yes, Lordship. 2888 oblique 2025.
Where is that? You have it? If you say yes, you should have enclosed it. All right, I think that'll do. No need to make any observation.
Yes, sir.
Plus,
Next case.
I'm appearing in that case, Your Lord, that's for 1, 2, and 4, Your Lord. 1, 2, and 4.
In this case,
Yes, I'm appearing.
in item 8.
Yes, yes.
Okay. Miss N. Fugan,
Appearing for respondent number 4, 5,
K. Fugan
and
appears
6.
for respondent numbers 1, 2, 3, and 6. I've already recorded your name. I've already recorded your name.
No, please, your lordship.
Yes.
Lordship, the petitioner was serving as headmistress of LP school and she retired on 31/1/2018, Lordship. And after her retirement, height imprint order stated 8/3/2019 and 13/6/2019, an amount of rupees 1,01,01,792 rupees was recovered from her pension, alleging that from period 1/1/87 to 31/3/2016, an excess payment was withdrawn by the petitioner, Lordship.
Where is the order?
Lordship imprint order,
Yes.
first imprint order, Lordship, Annexure 8, page 31.
Hmm. Then the second order,
Lordship, next page, Annexure 9, page 32.
33.
32, Lordship, Annexure
32.
9.
So amount recovered is 1,01,000,
Lordship, 790.
this much only, that much only.
Yes, Lordship.
Now, next question is, why have you come now? Recovery happened in 2019.
Lordship, I admit some delay has been caused, but still I'm receiving the pension, Lordship. I was not aware about the OM, Lordship.
When did you retire?
Lordship, I retired from on 13/1/2018. When I deposited the amount, Lordship,
13/1/2018
Lordship,
as,
headmistress, Lordship,
Yeah.
of LP school, lower primary school, and I deposited the amount on 14/6/2019, and same day the order of the respondents have issued OM, Lordship.
14/6/19.
14/6/19, Lordship. That OM I have annexed, annexure 11, page 37, Lordship.
Will issue notice,
Lordship.
heard Miss
MS Embora, Lordship.
MS Bora. MS M Bora, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the recovery of rupees 1,01,792.11 in terms of the order dated 8/3/2019 and 13/6/2019 on account of excess drawal of pay. Stop. The learned counsel submits that the petitioner retired as headmistress of LP school. Pamua Gogamukh in the district of Lakhimpur on 13/1/2018 and was asked to deposit the excess drawal, which she did on 14/6/2019. Stop. However, on the same day, the government of Assam in the finance department issued an office memorandum setting out the guidelines on which such excess drawal would not be recoverable. To stop the petition, the learned counsel for the petitioner submits that the petitioner was not aware about the office memorandum and therefore complied with the direction to deposit the excess drawal. Stop. She submits that since the office memorandum covers the case of the petitioner, the amount which has been recovered should be refunded back to the petitioner. Next, in view of above, issue notice of motion returnable by 4 weeks. Ms. N. Fukan, learned standing counsel, elementary education, accepts notice on behalf of
1 to 5.
respondent numbers 1 to 5. K. Fukan for respondent number 6. And Ms. R.M. Barua for respondent number. What about 7? Director of pension. I think Ms. K. Fukan will be 6 and 7. K. Fukan 6 and 7. R.M. Barua, respondent number 8. Petitioner shall furnish requisite copies of the writ petition to the learned counsels for the respondents appearing today within 2 days.
Lordship, the name of the school from which I retired at headmistress is numbers 176 Senior.
You just correct that. as headmistress of LP school. After that, you write number 176
Six,
Singhia
lower
Lower
primary.
Primary School,
Lordship.
Lakhimpur district only.
Yes, obliged.
May I please, Lordship? This is a matter relating compensation of appointment, my lord. My lord, what happened, my lord, in 2006, my lord, my father died while he was an headmaster of a madrasa, my lord.
Hmm.
Thereafter, in 2007, my lord, I had applied for compensation of appointment. That was not considered till today. Thereafter, my lord, some notifications came up from the government side saying that the compensation of appointment has been stopped and the pension has to be paid. On that, certain a group of people, candidates approached this court, my lord, and obtained an order. And accordingly, one application has to be filed before the authority. By Annexure 7, my lord, I have filed the representation, page 36, my lord. Page 36, my lord.
Yes.
My lord, I have filed the representation along with the requisite documents, my lord. So at this stage, my prayer will be, my lord, as because my case has not been considered till today, neither by the DLC nor by the SLC since 2007, my lord. So as I have filed the representation, this may be disposed of by considering the case of my candidation, my lord.
What do you say? Okay.
Page number 1, your lordship, he has wrongly written the petitioner's father's name, your lordship. Page number 1, your
How do you know it's wrong?
Gopal.
Huh? Page number 1.
Yes, your
Petitioner's father's late Gopal Palita.
There may be a typographical mistake, my lord, but the case is by annexure,
What is this? Copy paste?
maybe, my lord, does not my.
It should be Sabed Ali, isn't
Yes,
it?
my lord, this, it should be Sabed Ali. That wrong I have admitted, my lord, that has been done.
representation from Kodisa.
Any other mistakes? School is okay?
School-
Headmaster of
Yes, my lord, everything is okay.
Sidhuni Amis Madrasa. No, since you have filed your application,
Yes, my lord.
what is the requirement of filing writ petition? Your application you have filed already.
I have
They will
filed it.
consider.
I have filed it, my lord. But the thing is this, my lord, they may not, my apprehension is that they may not consider because of the order passed by this honorable court.
Hmm,
As I have annexed, my lord, at annexure 8, my lord,
hmm.
the last line, that page 43. Order dated 5/5/2025, my lord.
Hmm.
The last line is that, my lord. Paragraph 43, my lord. Before just paragraph number 8. In paragraph number 7, last line, it shall only apply to cases that are pending before the honorable, before this court on 3/4/2025, my lord.
So you kindly get a copy of the order. I think there's one order which says that it cannot be limited to this.
Right.
And accordingly, the direction was also given to consider the case. Your friend will be he may be aware about that.
Yes. I
Mr.
will collect.
Mr. Hussain may be aware of that. If you can get that order, we can
My lord,
take
I will
up the
check.
consider.
I think he is providing it.
Hmm.
It's- it's- কথা বলি তো।
Fukan,
I think,
consideration would be in accordance with law and in accordance with the set out principle. Doesn't mean that once court says you consider that you have to somehow ensure that they fit in.
Yes.
If they are not qualified or if their principals don't allow,
Yes, sir.
then the respondent should be at liberty to fire, to pass a reasoned order.
Yes, my lord, that is. Definitely.
Hmm.
If I am not entitled for,
Hmm.
the authority may pass appropriate order, my lord.
But tell me one thing, why you have come after so many years? 2006 was that,
That is.
2007 was the application. And
My lord,
is
I
is
was
this a
given-
second round? Is this a second round or
No,
first round?
First round,
First round.
first round, my lord. I was given the assurance that it will be placed before the DLC.
Let him get the.
No, those kind of assurance cannot be perpetuated again and
Yes,
again. I mean, you
understand.
cannot rely upon.
I understand, my lord. As because,
Doesn't give you a fresh cause of action every year.
yes, that.
Last year I tried, this year again I'll try, next year I'll try. That cannot be.
This is the order, my lord.
Mr. Hussein's case was different.
Yes,
In 2023, there was a specific direction that you cannot reject on the ground of what you call delay and all that. So state also did not file appeal. They DLC considered. Only the SLC did not consider, and probably because of the OM. Yours is basically a fresh case.
yes, that is.
It goes back to 2006 and 2007.
2007, my lord. The 2007, my lord, but it was not considered. Because as they have said that DLC is not sitting, SLC is not sitting.
Maybe, see, there may be hundreds of reasons,
Yeah,
but
that-
it doesn't explain your coming in
It is-
2025
It is
as if this is a fresh case.
It is my fault that I did not approach that, I admit, my lord.
Your lordship, in his case has not been placed in DLC, your lordship. And
Yes,
the previous case, that was placed before SLC and rejected, your lord. Previous case, Hussein's case, your lordship.
Correct, it was rejected.
Yes.
Mm. That's what I was saying. You have the order with you.
Yes.
Let's see. Give me that order. Sukan, what do? We dispose it off by giving liberty to the respondents to decide the matter in accordance with law.
Yes, your lord.
Okay. Heard Mr.
MK Mishra.
M.K. Mishra, learned counsel for the petitioner, and Ms. K. Fukan, learned standing counsel.
I am for respondent number 2, your lord.
Sorry, learned government advocate for respondent number 2. And Ms. S. Kaur for respondent numbers 1, 3, and 4. SC elementary, huh? Stop having regard to the nature of the grievance projected by the petitioner. The matter is taken up for disposal at the motion stage itself. Next, right, is the case of the petitioner that his late father was serving as a headmaster of Sidhuni Emi Madrasa Sidhuni. And he died in harness on 31/5/2006. Most of the petitioner therefore submitted an application on 10/9/2007, seeking appointment on compassionate basis. Stop despite the assurance given to the petitioner that his case will be considered. Comma, the same having not been done, the petitioner has filed the instant writ petition. Stop. The state government in the Personnel B department has come up with an office memorandum dated 18/9/2024, by which all compassionate appointments have been stopped in view of the introduction of the Compassionate Family Pension Scheme. Stop. A number of similarly situated persons aggrieved with the office memorandum had approached this court and all the cases were disposed of by a common order dated 3/4/2025, with the lead case being WPC number 342 of 2025, directing the respondent authorities to consider all pending cases for compassionate appointment in terms of the relevant guidelines of the state government. In terms of the said order, a notice was issued by the Personnel B department, the Personnel Department, no B, Personnel Department on 30/8/2025, requiring the persons concerned to submit their application with the requisite documents on or before 15th of September 2025 for considering the case of compassionate appointment. Stop. The petitioner, in terms of the said notice, had also submitted his documents before the authority concerned on 15/9/2025. But apprehending that the same will not be considered in view of the observation made by this court in WPC number WPC number 2324 of 2023, White order dated 5/5/25. Has therefore filed the instant writ petition. Stop. A perusal of the said order would go to show that the direction given by the court on 3/4/2025 in WPC number 342 of 2025 would be applicable only to those pending cases as on 3/4/2025. Stop. However, subsequently, this court in WPC number 2888 of 2025, White order dated 4/6/2025, has observed that consideration should not be limited to only those cases which were pending as on 3/4/2025. For the ends of justice and having regard to the observations made in paragraph number 9 and 10 of the order dated 3/4/2025. In WPC number 342 of 2025. Stop. Therefore, without expressing anything on merit and having regard to the fact that the petitioner had also submitted an application within time in terms of notice dated 30/8/2025. The petition is disposed of by directing the respondents to consider the case of the petitioner. In accordance with law. Your case has to go before the DLC also.
Yes. My representation, if it is considered to be appropriate, my lord, then the process will be there. Otherwise, my lord, they may reject it.
Spoken.
Yes.
Those bunch of cases which was disposed of earlier, isn't it? Those matters were mainly relating to the rejected case,
Yes, Your Lord.
rejected by the DLC,
SLC.
not SLC,
Yes.
not DLC.
Not all by SLC, Your Lord, some are by DLC also.
No, they had challenged the office memorandum, correct?
Yes.
Where was there any case in those batch of cases where that neither the SLC nor the DLC is considered? It is there.
That-
Hmm. So your case is a bit different.
Not there, so I say at this statement.
Your Lordship,
I was
please
not
go
there,
to-
so.
To the page numbers, 36, Your Lordship. 30, not 36, no, 37. 37, Your Lordship.
Lordship may see the issues
Yeah,
before the court, my lord.
everything is yes, Your Lord.
Hmm?
Point number 8, Your Lord.
What is this?
In page 28 of the judgment, my lord, the points were there.
Mr. Counsel, I think your case does not deserve any consideration. Because of number one, delay. Number two, because of want of immediacy. Number three, for being different from the other cases. Had it been a case wherein DLC had considered or SLC had considered but rejected, it would have been different. You're trying to bring out a case as a new case. It cannot be. Now, what did I say? On merits, without expressing anything on merit, something like that I say. Okay, before that, what did I say?
Lordship, the issue has. Lordship, that issue that whether my case was considered by the DLC or SLC, my lord. Your Lordship may see page number 29, my lord. Point number 3. That point has been taken care of in this case, man. Subject to correction, my lord. Whether the decision of the Supreme Court would apply to cases where DLC and SLC have not considered the application though the application had been submitted within time. That question was also there, man. Answer to that, my lord, has been reflected in page number 31, 9, subpara number 2. The entire process of considering the various applications for operational appointment and the decision to be taken in each case by the concerned authority should be complete within a period of 6 months from the date of receipt of the certified copy of this order by the concerned district commissioner, who is also the chairman of DLC, if the matter pertain to DLC. In other cases, chief secretary to the government of Assam, who is the chairman of SLC, if the matter pertains to SLC. So, subject to correction, my submission is that that question has been addressed.
What is the last line, therefore? No, the writ petition is disposed of. You cancel that. And also, taking into account paragraph number 3 and 9, 3, 9 and 10. 3, 9 and 10 of the order dated 3/4/2025, passed in WPC number 342 of 2025. From other writ petitions disposed of by directing the respondent authorities to consider the case of the petitioner in accordance with law. by way of passing an appropriate and reasoned order within a period of 6 weeks. Within a period of
6 weeks.
6 weeks from the date of receipt of a certified copy of this order. I said disposed of it. So paragraph 3 has saved you.
Yes, my lord. That has saved me. 3 as well as 9, my lord.
Now, if you come to page 33 also, then notice
Yes.
it also says serial number 8. Stage level at which the application of comparison is pending as follows. Next page, yet to be placed before LS DLC. This is also included.
Already if the petitioner has applied, this, I think with this petition.
No, according to him, he has applied.
Yes.
That he will verify and pass necessary orders. If not filed, though, he will be rejected. That much. All right. This is item number 10, is it? Is it fine to write? Okay, I'll be back. Yes.
May I please, your lordship, matter relating to non-payment of salary, my lord. My service was provincialized in 2021, my lord. After provincialization of my service, 2 persons challenged the provincialization of service of 3 teachers, including me, my lord. In those 2 cases, my lord, in one cases, stay order has been passed against me as well as other 2 persons, my lord. And that in that case, later on, my lord, the stay order was vacated and finally that case was disposed of with directions to consider the case of the petitioner of that case, my lord. And thereafter, my lord, an order has been passed wherein the claim of the petitioner of those 2 writ petitions has been rejected. And this that order has again challenged before this honorable court in another writ petition. In that writ petition also, stay order has been passed. And that order, writ petition was also disposed of by this honorable court with a direction to consider his claim within a period of 3 months, my lord. And within a period of 3 months, and an observation has been made that provincialization of service of the petitioner as well as the other 2 teachers shall be the outcome of that decision, my lord. Thereafter, my lord, more than 3 months has been expired, my lord, and nothing has been done. And in the meantime, my salary has been stopped, my lord.
Where's the direction?
Direction is at page number, final order is at page number 63, my lord. And relevant portion is at from page number 74, my lord. I'm a language teacher, senior most language teacher in the said school, my lord. So,
It starts from page 63 or 67.
yeah, 6. It is a relevant portion is from page number 74.
No,
my
not the
lord.
relevant portion, the beginning.
Beginning from, my lord, 65.
65 or 67. Which is the last
Oh,
case.
my lord, I'm sorry, 67.
This WPC 5772.
Yes, my lord.
This is the last case.
Yes, my lord. This is
You
the
were a party in that case.
Yes, my lord. I'm a respondent in that case, my lord. I'm respondent number 7 in that case, my lord.
Yes, number 7. Then what was the direction?
Direction from page number 74, my lord.
74. Please read.
Yes.
The relevant portion.
Paragraph 21, my lord. May I read?
Yes.
Accordingly, the respondent authorities are directed to reconsider the case of the petitioner by taking into account the claim of the petitioner as social science teacher. And the service of the respondent number 6, 7, and 8 have been provincial only as a language teacher and tutor. or in any other subject. In the event if it is found that the petitioner is a social science teacher and the service of the respondent number 6, 7, and 8 have been provincialized only as a language teacher oblique tutor, the petitioner be considered for appointment in the social science subject, as it would be as per the requirement of the provision of the Act of 2017. However, it is provided that if the respondent number 6, 7, and 8 have been provincialized only as a language teacher oblique tutors, the respondent authorities may consider retaining them in view of the fact that the provincialization of service of the teacher oblique tutor as per section 3(1)(11) of the Act of 2017 is for a minimum of 3 teachers, providing a scope of provincialization of services of more than 3 teacher oblique tutor in a given venture school. The respondent authorities are directed to complete the whole exercise as indicated above within a period of 3 months from the date of receipt of a certified copy of this order. It is needless to say that the provincialization of the service of the respondent number 6, 7, and 8 shall be subject to the outcome of the final decision as directed herein above. I am the respondent number 7, and admittedly I am a language teacher. I am the senior most language teacher, my lord, in the school. And altogether, 4 services of 4 teachers has been provincialized in that school. As per the pupils teachers ratio, my lord, more than 100 students are studying in that school, my lord.
You are a language teacher.
Yes, my lord. I am taking classes of Hindi, my lord. In earlier, my lord, when
Then what was the case of the petitioner?
his claim is he is a social science teacher. And he said that out of 4 teachers whose services were provincialized, 3 teachers are language teacher. His claim is that. But in the earlier round of litigations, the petitioner failed to prove himself as a social science teacher. Therefore, this honorable court within observations directed the authority department to reconsider his case and directed him to file an appeal, my lord, on that appeal to reconsider his case. And that was rejected. Thereafter, these writ petitions followed, my lord.
According to the petitioner in that case,
Yes,
respondent number 6, 7, and 8. 7 is yourself.
I'm
6,
admitted I'm a language teacher, my lord.
6, 7, 8 are language teachers.
Language teacher.
So in order of seniority, who is the senior most?
I am
6, 7, 8.
7.
You are in the middle, 7.
7. I am the senior most.
How many language teacher can be appointed, provincialized?
In a provincialized, as per the provision of the Act, my lord, there are 3 teachers should be provincialized in a elementary, upper primary schools, my lord. One is social science, one is maths and science, and another is languages. Or
Your language.
Languages.
Your language teacher.
But there is a provisions, my lord, if the pupil teacher ratio is, if a student is more than 100, my lord, then the RT Act will follow. And in this school, my lord, the students, enrollment of students is more than 100, my lord. Therefore, when the services were provincialized, services of 4 teachers were provincialized, my lord.
No, RT Act will follow means what? They can have more than 1 language teacher.
It can be, my lord.
If
that
it's
seniority will come.
pupil teacher ratio is more than 100
Yes.
is to 1 teacher.
In so
Then they can have more than 1 language teacher.
I have gone in many provincializations, my lord, in other schools, my lord. But I have found that, my lord, in that case, my lord, on the basis of the seniority, teachers were picked up, my lord. The access teachers, my lord, whoever the senior most, just picked up. So it can be better explained by my learned friend, my lord.
Who is Rina Khatun?
Rina Khatun.
Page 57.
57, my lord.
Page 57. Another order here.
Yes, that this is the earlier round of litigation. She also challenged the provincialization of service of provincial service of all these 3 teachers, my lord.
Including yourself.
Yes, my lord. And
That was dismissed,
that was also
rejected. Or what?
yes, my lord. That case was also disposed of with a liberty to liberty provide to her to file an appeal. She never proceed further, my lord. That all. She also claimed herself to be a social science teacher, but later on just found that she is an Assamese teacher, my lord.
You are working in 1210 number. Pachim Moradhaj,
Yes, my lord.
ME Madrasa. Is it
Yeah.
correct?
Earlier, yes, my lord, after provincialization, my post was adjusted as 1210 number Moiradas LP school, my lord. Prior to that, in Pachim Moiradas ME Madrasa, I was teaching, my lord. And my service was provincialized, and thereafter my service was adjusted to the base school, which is 121 number Moiradas LP School.
1210.
1210 number Moiradas LP School.
Earlier, where were you working?
Pachim Moiradas ME Madrasa.
It's the same thing.
No, my lord, not same thing, my lord. That is another school, ME Madrasa. There is a provisions to adjust the services in base school. No?
No, the earlier, it did not have any number. It was only a Pachim
Yes, my lord.
Moirad
Pachim
Hajj.
Moiradas. To different school, my lord.
Where have you stated it in your petition?
My lord. My lord, in page number 13, my lord, paragraph 14. That in this regard, it is pertinent to mention here that in the provincialization order of the petitioner and other three employees, no mention has been made against which subject days their services are provincialized. The services of the petitioner was provincialized as a senior most language teacher. After provincialization of service of the petitioner and other, they are adjusted to 1210 number Moiradas LP School as base school.
Which para you say? Page number?
14, page 13, paragraph 14.
One two one zero is the place where you have been provincialized.
I was provincialized in Pachim Moiradas ME Madrasa.
Mm.
After provincialization, my service was adjusted in this school as base school. My lord.
No, where did you first, your first appointment was?
My lord, at page number 8, paragraph 2.
Earlier it was in ME school.
Yes, my lord. ME
After provincialization, LP school.
It was adjusted at LP school.
I see. Then who is this petitioner? Page 67. He says he's a language teacher.
He claimed that he is a social science
Oh,
teacher
social science teacher.
in Pachim Moiradas ME
Mm.
Madrasa.
Mm.
In place, his service was not
Mm.
provincialized in social study teachers. And in his place, 3 teachers who are taking classes of languages are provincial. This is his claim, my lord. But before this honorable court, he failed to prove himself as a social science teacher. Therefore, this honorable court, without interfering the provincialization of services of all those 3 persons, directed the authority to reconsider, my lord.
Will issue notice at this stage.
My lord.
But Mr.
May I say?
M.A.I. Hussain, learned counsel for the petitioner. Who submits that the grievance of the petitioner is that he has not been paid salary from the month of February 2021 up to March 2022. And thereafter, from October 2023 till date. Despite the fact that, continue, no full stop. He is working as a language teacher in 1210 number Moirad Hajj LP School. Next para. a number of writ petitions have been filed with regard to provincialization of the teachers of the state school, wherein the petitioners was all, the instant petitioner was also made as a party respondent. Stop. The present petitioner claims that he was appointed on 26/12/1992 as Hindi teacher at Pakshim Moiradhach ME Madrasa. Stop. Subsequently, he along with 3 other teachers
Yes, madam.
had been provincialized. Subsequently, his service along with 3 other teachers were provincialized, and the petitioner was adjusted to 1210 number Moiradhach LP School as the base school. One Mohammed Sahidul Islam had filed WPC number 5772 of 2023, claiming that three language teachers have been provincialized. And he being the what teacher?
Social studies.
Social science teacher have been left out from provincialization in violation of the relevant provisions of the, what is the provision?
3-1.
Okay. In
11.
violation of the provisions of section 3(1) Roman, small Roman,
Roman
11 of the Assam Education, open bracket, provincialization of services of teachers and reorganization of educational institutions, close bracket, Act, 2017. Stop. The writ petition was disposed of. White judgment dated 25/3/2025. By directing the respondents authorities to reconsider the entire aspect of the matter. And to pass appropriate orders with regard to provincialization of services of the teachers of the said school within a period of 3 months from the date of receipt of a certified copy of the order. Stop. It was further provided that the provincialization of services of the private respondents, which includes the present petitioner, would be subject to the final order to be passed. Stop. Next para. The learned counsel for the petitioner submits that despite the aforesaid direction, no further process has been made. No further progress has been made, and instead, the petitioner has been deprived of his current and area salaries. Next para. In view of above, issue notice of motion returnable by 4 weeks. Mr. B. Kaushik, learned standing counsel, elementary, accepts notice on behalf of
1 to 4.
respondent numbers 1 to 4. Petitioner shall serve requisite copies of the writ petition. Mr. B. Kaushik within 2 days. Stop petitioner shall also take steps for service of notice upon respondent number 5 by registered post with AD within 3 days.
Next.
May it please your lordship. This writ petition, lordship, DLC recommended, lordship, page 32, lordship, relevant page 35. Relevant page 35, serial number 14, lordship. May I read, lordship?
Just a minute now.
Lordship,
43.
14.
That will be in page 35.
Yes, lordship, page 35.
Mohar Ali.
Manohar Ali.
Oh, Manohar Ali.
Manohar.
Yes.
Yes, lordship.
Yes, read.
The earlier proposal was placed before the DLC making held on 22/6/16 and rejected due to non-availability of post under the reserve category. Hence, considering the vacancy position under reserve category, it is decided to forward the proposal to the GOV for consideration. That is the remarks, lordship.
Mm.
Thereafter, matter forwarded to the SLC. In the meantime, office memorandum dated 18/9/2024 has come, lordship.
When was it forwarded?
Lordship, as per page 37, lordship, copy to Principal Secretary to the Government of Assam, Elementary Education Department, Dispur, Guwahati, lordship.
What is the date?
7/7/2023, lordship.
No.
Sorry,
That is the minutes,
yes, lordship.
but the forwarding of the
Forwarding
copy.
letter is not available, lordship, in the hands of the petitioner, lordship.
Please come to page 37.
Yes, lordship.
Signature.
Signature, yes, lordship.
Along with the signature, there's a date.
Yes,
What is
lordship.
that?
4823.
Uh-huh.
4823?
2023, lordship.
4823?
Yes, lordship. 48.
Mr. Pegu?
Yes, ma'am.
4823.
Yes, lordship.
Then OM.
Yes.
Then the same thing, like,
Yes.
what about the notice?
Notice, lordship, I have submitted the particulars, lordship.
Did you submit your application or your
Yes.
particulars
Yes, lordship.
and your documents?
On
When?
11/9, lordship.
11/9. And when did you file your writ petition?
8/9. I have filed this writ petition. That was acknowledged on 15/9.
Can we dispose it of? I heard Mr. N. Hussain, learned counsel for the petitioner, and Mr. G. Pegu, learned
Additional senior
additional senior government advocate.
for 1, 2, 3, and 6.
Correspondent numbers 1, 2, 3, and 6.
Madam.
Anyone else? Also had Mr. G. Pegu, learned standing counsel, school education, elementary, SC elementary, correspondent numbers 4 and 5. Stop having regard to the grievance projected by the petitioner. The writ petition is taken up for disposal at the motion stage itself. Full stop. Next para. It is the case of the petitioner. That his application for compassionate appointment was taken up for consideration by the district level committee bracket DLC, which DLC Dorang Mogaldai which held its meeting on 7/7/2023. Stop. Upon such consideration, the petitioner was recommended for consideration by the state level committee for appointment on compassionate basis. What do you mean by reserve category?
Reserve category means 5% lordship.
Oh, that 5%.
Yes, Lord.
Okay.
That-
Okay. And his name appeared at serial number 14 of the meeting minutes. Stop. Although the meeting minutes was forwarded to the principal secretary to the government of no, was forwarded to the state government. You will come under which one? Secondary.
Elementary lordship. 3, serial number 3 lordship.
To the state government through the principal secretary to the government of Assam, elementary education on 4/8/2023. But since the case of the petition has not been considered, the present writ petition has been filed. Next para, the learned counsel for the petitioner submits that the state government had come up with an office memorandum dated 18/9/2024 by which all appointments and for all compassionate appointments have been stopped in view of the introduction of the compassionate family pension scheme. Stop. A number of similarly placed individuals aggrieved with the office memorandum had approached this court by filing their respective writ petitions. And this court, by common order dated 3/4/2025 with WPC number 342 of 2025 as the lead case, disposed of all the writ petitions by directing the respondent authorities to consider all pending cases for compassionate appointment under the existing guidelines of the state government. To stop. In terms of the said direction, the personnel department had issued a notice on 30/38/2025 requiring all interested applicants to submit their documents and particulars for consideration for considering their appointment on compassionate basis. And the last date for submission of such particulars and documents was 15/9/2025. Stop. The learned counsel for the petitioner submits that the petitioner had also submitted all the requisites on 11/9/2025 before the Secretary to the Government of Assam Personal Department, and which was acknowledged on 15/9/2025. Stop. He submits that since the case of the petitioner is squarely covered by the earlier decision of this court, the respondents may be directed to consider his case, the case of the petitioner, for compassionate appointment. Next para, considering the above submissions and upon perusal of the materials available on record, the writ petition is disposed of by directing the respondent authorities to place the case of the petitioner before the next SLC for consideration in accordance with law and as per the relevant scheme in this regard.
Organized question.
May I plead your lordship? The petitioner before your lordship is an assistant teacher in high school, my lord. And he is paying for provincialization, his service as an additional assistant teacher, my lord. Although his service was, he was left out from provincialization when the school of the petitioner was provincialized in 2021. Although he has completed all the requisite qualification, because in his school at the time of provincialization from 2014 to 2016, my lord, the maximum numbers of students more than 124, my lord. And according to the rule 3(9) of the Assam Education Provincialization of Service Teachers and Reorganization of Educational Institute Act 2017, where it was clearly stated that if for additional posts, there must be there must be a more than for the particular subject must exceed 80 for one additional post, my lord. And he was left out, although in that 9 and 10 and last SSLC examination appear student is more than 124, 88 and
You're praying for your provincialization of your service as additional teacher.
Yes.
In which subject?
in social studies subject.
Social studies.
And the director
Social studies or social science?
state science
Social science. In terms of rule 3(9).
9. And the director of secondary education already submitted the proposal before the secretary to the Gov of Assam.
Where is that page number?
Page number 30, annexure 9. 3 posts of provincialization service of teaching staff of secondary high school under the said act, according with reference to the government letter and the legal view received from the Advocate General so-and-so on the Honorable High Court order in respect of the 4409/2021, where the petitioner school, that is page 31, serial number
You're
2.
referring to page 30,
30 is the proposal and the
annexure 9.
Hmm.
Then
and page 31, the name of the school of the petitioner, that is Sotogo,
Serial number 2.
2, my lord.
page.
Page 31. Sotagorja in Ancholik High School. Already the post has been created by the government, my lord,
Morrigan district.
Morrigan State. In 2023, my lord. But till date, his service was not provincialized as an additional teacher, my lord. Though the number of enrollment was higher than 124 in,
This is the proposal
this is the
for
proposal
one post,
for additional assistant teacher, my lord.
one post.
One post. He is
Then-
only one. He is,
Creation of 3 stuffing.
No, what does it mean? I don't understand. The detailed breakup of the posts are shown below. This is the existing.
This is the existing, my lord.
So where is the proposal for additional?
Here, proposal in page 30, my lord. The Director of Secondary Education issued a letter to the Secretary to the Govt of Assam, submission of proposal for creation of 3 posts for provincialization of service of teaching staff of the secondary high school under 2017 as Act as amendment by with reference to the letter number so and so, my lord. And in view of the legal view received from the Advocate General so and so of the Honorable High Court, order dated passed in WPC number 4409/2021, filed by the Parvati Devi, my lord. Though the petitioner has fulfilled the criteria. for-
What is this writ petition? Was it your case or somebody else?
This is different.
Some other case? Okay. Then page 31, what is this?
That is-
Morigaon,
the school of the petitioner name was reflected. That one post has a number, there's.
there's one post.
One post.
There's only one post.
Only
One
one,
post means for social science.
social science.
One post social science. And then number of tutor,
Tutor or teacher, whatever may be.
number of tutor again one.
One,
Then total number of post one.
one.
So number of posts is one, number of tutor is one. Total number of posts is still one.
One.
What does it mean?
Means, he is he is one of the additional teachers, my lord. That is why his name is not mentioned, but
Then there's no response to this till now? Any reply from the government?
he has filed a representation thereafter, my lord, on 23/10/2024, but till that nothing has been done by the authority, and he is still continuing as an assistant additional teacher. And his name also captured in the Dias Code, my lord, in 21 till 2024.
The proposal is for creation of posts.
Position of post.
Unless post is created, where does one provincialize somebody? So,
Please reply to.
Equal.
and what does the provision say that,
Provision same I have quoted in page number 8, my lord. The rule says, as per Rule 3(9) of the Assam Education Provincialization and Service of Teachers and Reorganization of Education Institute Act 2017, where it was clearly stated that for provincialization of additional teachers, as the cases may be for additional subject, as the cases may be for a particular subject, including the core subject, in addition to the post mentioned in section 317, in any Venture High School or Venture High Madrasa or Venture Higher Secondary School or Venture Senior Secondary School, the minimum student appearing in the last final examination of the highest classes of the said school for the particular subject must exceed 80, my lord, for additional post. And if your lordship go through the page 28,
that means students appearing in the last final examination.
yes,
How many students appeared?
that is
More than 80.
No, more than 80, 101 in 2014, last 3 years, 2015, 88, and 2016, 124, my lord. That is Annexure 7, page 28. Thereafter, his service was not provincialization after fulfilling all the criteria.
Okay, so your basic case is that you want the post to be created so that you can be provincialized. And creation of posts is justified in view of the fulfillment of Rule 3(9) of the 2017 Act. Wherein for the last 3 years, consecutively 14, 15, 16, there are more than 80 students who have enrolled for examination. Okay. Will issue notice? Art Miss
And appearing for one.
Bujur Borwa, is it?
Yes.
A. Bujur Borwa, learned counsel for the petitioner who submits that the petitioner is working as an assistant teacher in Chota Garjan. How do you pronounce this? Chota Garjan.
Ansolik High School.
Okay. Chota Garjan Anchalik High School in Morrigan district, and has been working continuously as such since 25/4/2005.
2000.
Stop. The Learned Council submits that as per Rule 3 bracket Roman 9 of the Assam Education open bracket, provincialization of services of teachers and reorganization of educational institution close bracket Act, 2017. It is permissible to create additional posts when the minimum students appearing in the last final examination of the highest class of the school for a particular subject exceeds 80. To stop further, a second additional post can be created if the number of students appearing in the final examinations in the highest class exceeds 150. To stop, the Learned Council submits that in the year 2014, 2015, and 2016, more than 80 students had appeared for the HSLC examination from the school consecutively. And therefore, the respondents should be directed to create an additional post so that the services of the petitioner can be provincialized. To stop, the Learned Council submits that the Director of Secondary Education, Sam, in fact, had already submitted a proposal to the state government through the Secretary to the Government of Assam, Department of School Education, on 17/11/2023 for creation of 3 posts for provincialization of the services of the teaching staff of the schools concerned, including the school where the petitioner is working. Stop, however, despite the same, as no further steps have been taken, petitioners before this court. Expedite, in view of above, issue notice of motion returnable by 4 weeks. The Speed as Learned Standing Council Secondary accepts notice on behalf of the
1, 3, 4, and 5.
respondent numbers 1, 3, 4, and 5. Mr. G. Pegu, additional senior government advocate, accepts notice on behalf of this foreign number 5. Who is 2? Finance.
Finance, R. Borwa.
This RM Barwa. RM Barwa, isn't it?
Your Lordship, A. Chaliha.
Okay, Mr. A. Chaliha, Standing Council Finance Department.
A. Chaliha, I will inform you.
A. Chaliha, Standing Council Finance, accepts notice on behalf of respondent number 2. Notice is therefore complete. Petitioner shall furnish requisite copies of the writ petition to the Learned Council appearing for the respondents today, within 2 days. List again after 4 weeks. Pendency of the writ petitions, not a bar for the respondents to take necessary steps for creation of the posts.
Must
Yes.
keep you blessed. It's okay. My pleasure, Lordship. Lordship, petitioner is a student of Assam Downtown University, Lordship.
Is there?
Petitioner is a student of Assam Downtown University, Lordship. Lordship, he got arrested on 18/8/2025 in connection of so and so. Now he is not allowing, the university is not allowing to attend his class, attend the class, Lordship. So,
He got arrested in connection with?
in connection with Park School PS case number 105/2025. Lordship, FIR is at page 15, Lordship.
Yes.
And thereafter he got bail, Lordship, because he is a child in conflict, Lordship. He got bail on on 22/8/2025 from the Principal Magistrate Juvenile Justice Board, Lordship.
Order is there?
Order that, Lordship, Lordship, page 19, Lordship.
What is the petitioner undergoing? Which course?
Lordship.
What is he studying?
Studying physiotherapy.
Physiotherapy.
Yes, Lordship.
Okay. And the date of the incident or the FIR is on which date?
Lordship, 18/8/2025, Lordship.
18/8.
18/8, Lordship.
Hmm.
Lordship, 16/8, Lordship.
Who has lodged the FIR?
Laws,
Hmm? Where is the original copy?
this person, original of the Lordship is
At page 17.
17, Lordship.
Who is the signatory? Who are they? They are also students.
Lordship, they're local people, Lordship.
Any application?
Yes, Lordship. Lordship, at page 21, Lordship.
21.
Lordship.
Was there any formal suspension?
No, Lordship. Without any formal suspension, there, he is
Hmm.
not allowing to classes, attend the classes, Lordship.
We'll have, yes, you are there. We-
I am for 3 and 4, Lordship. Lordship, this is respondent number 5, Lordship, the university. The
Notice will have to go.
Lordship,
Notice will have to go, isn't
yes,
it?
sir. And
On behalf of responding.
You just see.
In the meantime, he may be allowed to class, Lordship, there because there may be irreparable loss, Lordship. He is a student of physiotherapy. Classes are going on, Lordship.
notice and even industry service to the university, Lordship. Without hearing the university.
Since when you're not attending class?
Lordship, since 16/8/2025.
16 you were arrested, isn't it?
Lordship,
And released on bail on
bail, Lordship, 22, Lordship.
22/8.
Lordship,
And when did you file this writ petition?
with petition file, Lordship. Before puja vacation.
You don't know.
It was at 22/9.
22nd September, I think.
It is on 22/9, I think. Yes.
So on the first day itself, you won final relief.
Notice is and taken for dusty for
So
university.
interim maybe, Lordship. He may be allowed to class, Lordship, because he's a student, Lordship.
I know he's a student, but why is he playing with the tricolor like that?
This is.
It's a very serious thing. Anyway, we'll issue notice. You will serve notice by Dusty. You'll stay by Dusty.
22nd, then
Uh,
another case is fixed, Lordship, regarding the same subject matter. This may be
22nd,
Twen-
which case?
WPC number 5511/2025,
22nd of this month.
Lordship.
By which order?
Not this issue, Lordship.
By which order? Order passed on which date?
I may be allowed to say.
See, check. Another case means there are how many people out here in the FIR?
So there are 5 students, Lordship, 3 are allowed and 2 has not been allowed, Lordship.
Huh?
2 students.
My Lordship, we're not allowed by the university to take the classes.
I see. So 2 have come before this court.
Yes, Lordship. 2 has come.
5 arrested, 3 have no grievance. They are attending class.
Lordship.
Remaining 2 are not allowed. One is this present petitioner and the other one is that case. What was the order passed in that case?
2025, Lordship.
Huh? What is the order? Don't show me, just read and tell me.
I had Mr. So-and-so Learned Council appearing for the petition. I also had Mr. So-and-so Learned Council appearing for the Higher Education Department. Mr. So-and-so Learned Council appearing for the respondent number 2 and so-and-so Learned Junior Government Advocate appearing for the respondent number 1. Issue notice returnable 22/10/2025.
Heard Miss
NJ Begum.
NJ
Begum.
Begum, Learned Counsel for the petitioner, who submits that the petitioner is aggrieved with the action of the respondent number 5 in not allowing him to join classes on account of being arrested on 16/8/2025 in connection with what is PGR?
Pragjyotishpur, Lordship.
Okay, in connection with Pragjyotishpur Police Station case number 105 of 2025, registered under section 61 bracket 2/352 BNS, read with section 2 of the Prevention of Insults to National Honor Act 1971. Stop. She submits that altogether there were 5 persons accused of the alleged offense, and 3 of them have been allowed to join back their classes, while the petitioner and another person have not been allowed to do so. Next para, issue notice returnable by 22nd October 2025. Mr.
As Bhuya,
S. Bhuya,
it's a higher division for.
SC had
for
accepts notice on behalf of respondents 3 and 4. Miss
S data on behalf of H. Umwa.
S. Deka appears on behalf of Mr. A. Chamwa, who represents respondent number 2. What about 1? Union of India?
Oh.
You are there.
Oh, Bhuya,
Okay, okay,
well,
okay. Miss K. K. Pukan, Lanet CGC, accepts notice on behalf of respondent number 1. Petitioner to serve requisite copies of the writ petition to the learned councils appearing today for the aforesaid respondents. Next para. Petition is allowed to serve notice by way of Dasti upon respondent number 5. Within a week from today, through the registry of this court, and thereafter to file file an affidavit as proof of service. Next para, issue notice on the interim prayer as well, returnable by 22nd October. List accordingly.
May I please your lordship? My lordship, beg your pardon, my lordship, only some time, my lordship. It's because I don't have the file in my misplacement. Only
Okay, as paid for, matter starts passed through for the day.
May it please your lordship.
Yes.
My lord, before the vacation, we moved this petition. In fact, your lordship was pleased to pass an interim order also. But after filing of the writ petition, certain developments took place. Therefore, we had to withdraw the earlier writ petition and file the present petition. My lord, in short, the point involved in this case is this present petitioners, they are all faculty members of the Central Institute of Technology, Kokrajhar. CITS, K. Now, initially, we are appointed against contractual posts, that too pursuant to advertisement and all. Subsequently, our services were regularized and we are getting regular scale of pay and all. Now, only problem with the authority is they are not giving us the seniority for the period we served under contractual. Now, regulation of the institute, which your lordships will get.
Have you annexed the order?
Yes, yes, earlier order.
Earlier
Milord.
order?
Yes, yes.
Let's have a look at that.
Yes, earlier order. One second, Milord. The facts are actually lengthy. Yes. Page number, order is dated.
Page 158, I think.
Oh, so we have craved leave, my lord, anyway. My lord, this was the order which your lordship passed. এখন দিও না। গাঁথি দিয়া নাই নেকি? No. 156, my lord. One withdrawal order নালাগে না, কোর্টে স্টেট হয়ে বিচাৰিছে, yes. Please come to page 159. Having regard to the projection made by the petitioners, it is provided herein that till the next returnable date, respondent shall not make any deduction in so far as the present petitioners are concerned, if the amount has not already been deducted in the meantime. Further, the promotion contemplated in terms of notification dated so-and-so will be subject to the outcome of the writ petition. Now, my lord, since these are all CAS promotion, therefore it can wait, my lord. There is no difficulty. Now, I was trying to draw your lordship's kind attention to the regulation at page number 161, my lord.
What is the reason that you had withdrawn and refiled? Anything new here?
No, actually now because, my lord, in the meantime, promotion orders has been issued. And plus a fresh advertisement has been issued.
So
For
you're
making
challenging
fresh
this now?
Yes, because, my lord, these are all promotion under CAS, Career Advancement Scheme. So if they are promoted, my lord, will miss the bus for all time to come. Now, if your lordship would kindly, the main bone of contention is in our favor. If your lordships that come to page 162, and the operative portion is at page 169. .25 on top. Previous regular service, whether national or international, as assistant professor, associate professor, or professor or equivalent in university, college, national laboratories, or other specific scientific professional organizations such as so-and-so, should be counted for direct recruitment as an assistant professor or associate professor. Now, please come to, provided that, please come to F. The previous appointment was not as a guest faculty for any duration or ad hoc in leave vacancy or less than 1 year duration. That's important. Ad hoc or temporary service of more than 1 year duration can be provided the period of service was for more than 1 year. The incumbent was appointed on recommendation of duly constituted selection committee. Incumbent was selected for permanent post in continuation to the ad hoc or temporary office. 5, incumbent was drawing gross emolument not less than monthly gross salary at the initial stage of a regularly appointed assistant associate professor. At the time of selection, negotiated terms and conditions clearly mentioned, period of experience, nature of experience, etc. So under the regulation of the published by AICTE, which is applicable in case of the respondent institute, now this service is to be counted. That is the basic bone of contention. Now in 1/11/23, a process was initiated. Page 112. This is where our problem starts. Now kindly see, my lord, at page 112. Applications are invited in the prescribed format enclosed herewith from regular teachers fulfilling eligibility criteria for promotion up to 15/12/23 in accordance with the provisions of the AICT notification dated so and so. Pursuant to this notification, we applied. Our cases have not been considered. And the impugned minute is at 119 and the relevant portion is at 125
This notification is for what?
for recruitment, my lord, for
Recruitment?
career progression. We appeared in the interview pursuant to that notification at page 112. Then, my lord, we applied. Then there was a resolution was taken by the highest body of the institute at page 125.
No, promotion means what? Promotion to?
CAS, Career Advancement Scheme.
Oh.
My lord, if we rendered 3 years service as an assistant professor, then we qualify to become associate professor. Similarly,
You all are assistant professors.
we are all, yeah, mostly we're assistant, 1 or 2 are associate. Na?
And
That we have explained in the petition.
promotion, assistant professor's promotion will be to the
Yes, yes.
professor.
There are different levels, 11, 12, 13. Those are there. We'll explain, my lord.
And for professor, what is the promotion?
That is also there. Under CS, one can reach professor also.
No, this notification is for promotion up to which level?
To all position. Now, before that, if your lordship would kindly permit me to place 125, my lord, the relevant resolution which was taken in respect of our promotion. Page 125, then I'll come to that regulation where the promotion criteria is mentioned. A resolution. The board permitted register in charge CITK.
You are reading from
And
120?
page 125, my lord, resolution of the selection committee.
Okay, yes.
Yes. The board permitted the registrar in charge CITK to open the seal envelope containing CS results in presence of board members. It was further resolved that the decision on faculty members against whom there are CAG objections, these are the petitioners, because we are given pay scale. So they say that how come you have given him? Will be taken after their eligibility is recommended by 3-member committee to be constituted for the purpose by Chairman BOZ. As the period of contractual assistant engagement of 14 assistant professors, including the petitioners, cannot be counted for pay protection and CS promotion, the proposed committee will also look into their cases. Since the period of contractual engagement of the 14 assistant professors cannot be considered for CS promotion, the proposed committee will also examine their cases separately. A report of this said committee shall be submitted to BOG for further consideration and necessary action within 10 days. Now, what had happened, my lord? Once the pay was revised, we were given the pay benefit from an earlier date. Then, my lord, CSG raised an objection. How come you have paid this amount? Now, the stand of the institute was they are eligible because they were regularly selected. And secondly, my lord, this aspect that our past service cannot be counted, this is plainly contrary to the regulation which I have already placed, where it says ad hoc or contractual appointment beyond 1 year will be counted for earlier service. So on both count, my lord, their stand is on a fragile ground. Now what had happened? We applied for due consideration pursuant to that 1/11/2023 notification. Our cases have not been considered till date. On top of that, they have already undertaken a promotional exercise, which was made subject matter of the earlier writ petition. Now, my lord, they have issued a fresh advertisement. So at this stage, our prayer is, my lord, no action should be taken pursuant to the fresh advertisement.
Where's the advertisement?
Yes, 154. And my lord, the 3-member committee report is in our favor also.
Is
Please
it,
come to 154, my lord.
is the next here?
Yes. Applications, 154. Applications are invited in the prescribed format enclosed herewith from regular faculty member of CITK fulfilling eligibility criteria for promotion up to 3625. My lord, this date is of no relevance for us because if we are considered on with effect from 1/11/2023, in which even, my lord, would have made the mark. Now we cannot. In accordance with the provisions of AICT notification, so 2 copies of the filled in application, etc. So this is the fresh advertisement. Now, my lord, we have explained the position. Now, if your lordship would kindly come to page 152 for a moment, my lord. This is the result of the CAS exercise undertaken pursuant to 1/11/23. Now, serial number 3, serial number 5, and serial number 6, their past services were counted, though they were, my lord, contractual appointees like us. Now, our case is, my lord, if this, the other promotional exercise will naturally be subject to the outcome of the case. Now, we can't go on adding, my lord, and this 3-member committee, a recommendation is in our favor. We have made a categorical averment at para 24. 24 and 26. Now, if your lordships would kindly come to page 23. That the petitioners beg to state that the petitioners on 27/8/25 had a discussion with the registrar in charge regarding the issue of their promotion under CS. After the discussion, the petitioners came to learn that the report of the 3-member committee was placed before BOG during the 40th meeting held on 20th of August 25, and the report was supposed to be sent to the Ministry of Education, Government of India for further action and implementation. During the meeting, registrar also expressed that the committee's recommendations were positive. It was further informed by the registrar during the meeting that report of the committee has not been forwarded to ministry till 27/8/25. Thereafter, petitioners number so-and-so had submitted individual representation before the director on 28/8/25 with a request not to initiate any fresh advertisement for promotion of the incumbents under CS. So, my lord, that report is also reportedly is in our favor. Now, my lord, if our past service is counted or countable, then that's the end of the matter. Now they are multiplying things, my lord. Tomorrow there will be another advertisement, we'll have to file another application. Now, my lord, only difficulty is if our cases are not considered pursuant to 1/11/23 notification, then we lose everything, my lord. Because every time there is an advertisement, we'll have to apply afresh. Then our eligibility will go down. That is the problem. So therefore, at this stage, what I am praying is, my lord, the promotion which has been made, that will be made subject to outcome of the case, and the fresh advertisement, my lord, they should not be permitted to go ahead. And let the authority appear, let the matter be decided within a month. Huh? And it is a promotion and the career advancement scheme. It's not that somebody will take over somebody's position. That therefore, nobody's interest would be effective. But our perspective is, if the promotion CS undertaken pursuant to 1/11/23 are not given effect to, then we lose the seniority for all time to come. That is the situation, Bill.
The 40th BOG meeting minutes is annexed here,
Yes, my lord.
page 136.
Yes, my lord.
Anything relevant to your case in this?
আছে নেকি? Only thing is, my lord, the 30th board meeting resolution was approved. 40.03. On the recommendation of the 39 BOG under agenda, a CS committee was constituted to examine and recommend CS promotion based on result of interview held on so-and-so for the following categories of faculty. Faculty not related to so-and-so, faculty under audit paras, that the petitioners. The report of CS committee provided a seal coverage is being placed before the BOG member during the meeting. More than this, my lord, nothing is, forthcoming.
So what is the finding or the report of the three
My
members?
lord, as was given, as we have stated in paragraph 24, the registrar gave us to understand that it is in our favor. Earlier also, they have taken this stand, my lord, that we were given the increment and all and the pay scale because we were qualified and were duly appointed. Only because CAG had raised the issue, therefore, my lord, the authority is now taking a back foot.
The report is to be sent to the ministry.
Yes,
It has not been sent.
it has not been sent.
What-
At least until 27/8/2025, as we have stated, it was not sent.
What is the reason for that?
We don't know. We don't.
Is it because of CAG?
Yes. Maybe. My lord, as I submitted, the bone of contention is whether our past service is to be counted or not. If yes, the answer, everything has to fall in place. And if your lordship would kindly come to page 114 against the CAG's view, my lord, page 114, my lord. Now kindly see present status on audit para number 2.6 of the financial year regarding irregular grant of pay protection at the entry level to the newly recruited assistant professor on the basis of discussion held in ACM on Iman. Please come to the after that chart, my lord. Hence, the data shown above confirms that no excess increment was allowed to them. The number of increments due to them on the basis of past service rendered in the institute. However, the noting recorded as pay protection was erroneously done, that may please be considered as allowing increment admissible to them for rendering past service on contractual posts of assistant professor, subsequently regularized without any break in service by the competent selection authority. Now, what they perceive, my lord, the use of the expression pay protection may not be appropriate, but what should have been mentioned is increment. So this is the stand of the university. Qua the audit objection. So at end of the day, what transpires is, my lord, the petitioners are suffering just for nothing. Problem is, my lord, they are not taking the decision. So, my lord, at this stage, all that I am praying is, my lord, they should not undertake any fresh promotional exercise pursuant to the advertisement at page number 154.
How does it affect you? 154?
No, my lord, what happened? No, yes. Now, please come to page 154. Applications are invited in the prescribed format enclosed herewith from regular faculty members of CITK fulfilling eligible criteria for promotion up to 36/25. We are not eligible up to that date, my lord. We are eligible as of, my lord, 23. And that we have explained in paragraph 26, my lord. Paragraph 28, my lord. You have explained the position. Please come to page 26, my lord. That the petitioners beg to state that results of their interview for promotion under CAS pursuant to we have not been declared till date. on account of the impugned decision of the Board of Governors contained in resolution number 39.12 adopted in its meeting held on so and so. It is pertinent to mention herein that petitioners number 1, 2, 3, 4, 6, and 7 have appeared in the interview for promotion to the post of associate professor, whereas petitioner number 5, 8, and 9 have appeared in the interview for promotion to the post of assistant professor selection grade. It is further stated that if the petitioners are not promoted in terms of the earlier notification, they may once again apply for their promotion under the subsequent notification dated 18/9/25. The petitioner begs to state that unless the said results are declared before the last date of submission of the application, that is 17/10/25, as per the present advertisement for promotion in terms of subsequent notification dated 18/9/25, they would be deprived of the opportunity to apply under the said advertisement. That means, my lord, I must be in the feeder cadre before this date, 36/25. Then para 29 also, my lord, that the petitioners beg to state that respondents are well aware about the facts stated herein above. However, with an ulterior motive to deprive the petitioner from applying for promotion under CS, the impugned notification has been issued. It is stated that unless the results of the earlier promotional processes under CS are declared, petitioner will be left in a state of uncertainty and will be deprived of fair and equal opportunity to apply under the said advertisement.
Do you mean to say that you have already qualified in 2023? Now, if they come and extend it up till the 30th of June, 2025,
Pursuant to that 18.
those who have come subsequent to you
Yes,
would still
they would
emerge?
still a march over us.
Mhm.
So therefore, at this stage, all that I am praying is, my lord, the promotion exercise which they have undertaken, that will be subject to the outcome of the case. And pursuant to the impugned advertisement, my lord, they will not undertake any further promotional exercise till they appear and file their affidavit.
So in this fresh writ petition, what you have included now is this
The fresh
advertisement.
advertisement.
Anything else
No.
apart from that?
So presently, my lord, our Sue is pincing with the fresh advertisement. 154.
Is anyone appearing at this stage?
Actually, they do not have a standing council, my lord. Yeah? No, CGSC will be a formal party. How about it? Even last occasion also, my lord, lordship directed us to take. Order to 159 क्यों लिखा है?
You're also against that recovery.
Earlier, no, at this stage, it is not required. At this stage, they may not be very keen. Of course, on last occasion, lordship, they directed them not to make recovery.
Please write down. Heard Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. R. M. Teka for the petitioners, who submits that the petitioners were initially appointed as assistant professor in Central Institute of Technology, Pokrajhar, bracket CIT Gate, close bracket, on contract basis after due process, and that their services have been regularized sometime in the year 2014 and 15. To stop their past services have been treated as incentives, and therefore they were allowed to count the same with monetary benefits. Stop. Since there was an attempt on the part of the respondent authorities to recover the monetary benefit given to them, in view of the Comptroller and Auditor General's objection, and pending the report to be submitted by the constituted three-member committee, the petitioners initiated WPC number 5595 of 2025 to stop this court, white order dated 22/9/2025, issued notice of motion, and at the same time directed that deductions should not be made from the petitioners as an interim measure. Stop. However, during the pendency of the writ petition, since there were certain developments, the petitioners sought withdrawal of the writ petition, and the same was permitted by order dated 25/9/2025 with liberty to file afresh. Stop. Hence, the instant writ petition has been refiled. Stop. Next para, Mr. K. N. Chaudhary, learned senior counsel, submits that what the respondent authorities have done in the meantime is that they have issued a notification on 18/9/2025 inviting applications in the prescribed format from regular faculty members of CITK for promotion having the criteria up to 30/6/2025. With the last date as 17/10/2025 for submission of the application. Stop. He submits that pending decision to be taken by the respondent authorities concerned, if the fresh advertisement is allowed to proceed, those who have come into service much later than the petitioners would steal a march over them. Stop. Referring to the AICT norms, more particularly clause 2.25 bracket small f, the learned senior counsel submits that it is clear that past services can be counted, provided that the same was secured through due process. Full stop. The learned senior counsel submits that since there is no dispute with regard to the manner in which the petitioners have been appointed, the benefit accrued to them should be made available to them before resorting to the fresh advertisement in terms of the impugn notification dated 18/9/2025. Next para. In view of above, let notice of motion be issued, returnable by 4 weeks. You are also CGC? Mr. G. Pegu, Lanet CGC, accepts notice on behalf of respondent numbers.
One Milord.
Respondent number 1. Petitioners to furnish requisite copies of the writ petition to Mr. G. Pegu within 2 days. Stop the petitioner shall take steps for service of notice upon the remaining respondents by registered post with ADDU as well as by usual process. Next, madam. Having regard to the projection made by the petitioners, it is hereby directed as an interim measure that status quo as on today shall be maintained with respect to the impugn notification dated 18/9/2025 bracket annexure Z2. Z then number 2, okay, Z2.
Yes,
We'll list again after 4 weeks.
deep. Recovery part, they will not do as was directed earlier. Milord.
It is also further provided that the respondents shall also not resort to making recovery, oblique deductions from the petitioners.
In terms of order dated 28/24. Milord.
Where's that order?
Yes. 28/24. 1 second. Milord. Page number 115.
In terms of the office order dated 28/2024 bracket annexure R.
Deep.
Please, Your Honor. In this, the replies are still awaited from the opposite party. Apart from respondent number 8, no reply has come in the main writ petition. And the IA, no replies have come in there, in that as well. And I'm not sure why it's been put in the stay vacating, because there's no application being filed for vacating the stay.
You are for the applicant.
I am for the petitioner
Petition
and the applicant.
and also the applicant,
Yes, in IA 2755.
which is for
So that essentially what had happened in this matter, Your Honor, is that we had challenged a transfer order. Now, I'm a principal of a local LP school, and a transfer order was passed against me, which I put to challenge on a variety of grounds. It's essentially it's illegal. It's got provisions of law that's not been followed. It's also punitive in nature. So sequence of arguments have been raised, but in that on the 8th of January, an order was passed protecting me, saying that no coercive action to be taken. In the face of that order, a second show cause notice was issued to me on the exact same grounds as earlier. That is what I put to challenge in the IA,
In the IA.
in this IA.
This
And-
this is not a stay vacation.
No, it's not.
Okay.
That's what I'm saying. In fact, there was even a contempt because they've stopped my salary, but that's part of a different set. So my humble submission is that we should proceed with the matter as soon as possible, and a reply should be forthcoming.
Is there any category for such kind of stay vacation applications? Category code?
There should be, Your Honor. Usually when a stay vacation application is filed, then this column is invoked.
So perhaps it's because of some mentioning of some code that it has been listed like that.
Your Honor, this matter was already listed earlier in 21st of August. So that time it didn't come in this category. It may be an error.
Who's appearing for the other side?
I'm putting as per number
Hmm.
8, my lord.
Num-
Just immediately, my lord, I have received the copy of the IA file.
Hmm.
Just 3 minutes ago, my lord, just served the one copy, my lord.
So the IA is actually not against him because I'm assailing a show cause order, which he is not, he is not issued it. So there's no,
My lord, I have not done for this, my lord.
very well, that's,
Maybe, my lord, taken up because the state respondent also, my lord, have to file affidavit,
You are for the,
private
Yes.
respondent. 8.
okay.
there are certain allegations that I'm making against
Hmm.
him, which is in the main writ petition.
Main petition, my lord, I have already filed my affidavit.
This IA is against the show cause notice.
That's correct.
Second show cause notice.
That's correct.
Perhaps you may not have to respond to this. You have received a copy?
Given- I think copies were given. To R1 to R7. Copies to R7. It was given.
No, you have a copy or not?
I think he has a copy. It is of course. I got it on the, I think 2 days after, within August. But if there's an issue, I'll definitely serve another copy. We don't want to be held up on that.
Mr. Bora, are you sure you have a copy? You have a copy? No, right now or right, thing is that have you been served or not? Because I don't want you to make the same submission again next day. That copy is just given to me. There's an acknowledgement here.
Yes, I've got the acknowledgement, Your Honor.
N.
It has been
Sharma.
served on 29/8/2025.
Anyone? N. Sharma for SC elementary education. So that means you have it. Okay. The learned counsel for the applicant. Stroke writ petitioner, Mr.
Didas, Your Honor.
D. Das submits that the interlocutory application is for stay of the second show cause notice dated 11/8/2025 issued to the applicant stroke writ petitioner. And therefore, it is not an application for vacation of stay.
In fact, a status quo order in this has also been passed on 21/8.
Stop. He submits that therefore the application has been wrongly listed under the stay vacation
Column.
column in the cost list. Stop. Mr. B.K. Bora, Standing Counsel Elementary, as well as Mr. R. Sharma, Learned Counsel appearing for respondent number 8, seek some time to respond to the application by receiving instructions. In view of above, and as paid for, let the matter be listed again.
The stay orders the interim orders may be continued on in both the matters, in the writ petition also, as well as in the
After a
I-
week, when? After 2 weeks. There's an interim order in the main,
please,
Already-
yeah.
in the IA.
The interim orders in both. So the first interim order is passed on 8/1/2025. It says till the next returnable date, no coercive steps to be taken against the petitioner. This has been extended from time to time. The last extension was on 4/6/2025.
Till the next date of listing, the interim order passed earlier shall continue. All right.
And similar position even for the IA. The IA, the interim order was passed on 21/8.
Now this order will go in the IA.
Both, there's a interim in both, Your Honor.
I know. This order is basically on the IA. In the writ petition, you write, list the matter again after 2 weeks, along with IA C number 2755 of 2025. Stop till then, the interim order passed earlier shall continue.
And the affidavits may be invited, Your Honor. They haven't filed the affidavits because since January, we've been waiting for the affidavits.
You'll file.
They made the submission way back in the 8th of January. They said they'll take instructions.
Respondents also to file their affidavit in the meantime.
Deeply obliged. Your Honor. Yes, ma'am.
Please, Your Lord. My lord, here I have filed an IA, and in this IA, my lord, there is some typographical mistake, my lord. On this IA is filed just to, my lord, rectification.
What is the mistake?
My lord, only, my lord, in the IA, my lord, 2586, in index, my lord, at the first page, name is Rokib, ROKIB, but same is typed as ROBIK, Robic. This must, my lord.
Which page number?
My lord, index, my lord, in the index, my lord, in IA 2586.
It should be, what should be the correct one?
My lord, it should be Rokib, ROKIB. In cost title, my lord, that is correctly done, my lord.
Any other mistake?
And other mistake, my lord, as per this, my lord, index, the CI sheet also, my lord, that committed. CIS sheet, my lord, case information.
Your good name?
M. Hussain.
Heard Mr. M. Hussain, learned counsel for the applicant, who submits that this application is filed for rectification of the name of the applicant in the index of IA C number 2586 of 2025. And also this in the CIS
Yes.
in connection with WPC number 2803 of 2021. Stop the learned counsel submits that inadvertently, instead of Rokib Uddin Ahmed, ROKIB, Rokib Uddin Ahmed, it has been indicated in the index as Robik, ROBIK, Robik Uddin Ahmed. Stop. The former is the correct name, and accordingly, same may be allowed to be rectified, as well as in the CIS. CIS, the registry will do.
Yes.
I think. Next para, considering the submission made and upon perusal of the materials available on record, the interlocutory application seeking rectification of the name of the applicant is hereby allowed. Stop. The name shall now be read as Rokib Uddin Ahmed. IA stands disposed of as allowed.
ST may be directed to allow.
Then what is this IA 2586?
My lord, IA was, my lord.
This is for?
This is for, my lord, vacation of the interim order. Only
Okay.
here is, my lord, the Honorable High Court, my lord, passed, and my lord.
All right, first you make the modification,
My
then we'll see.
Yes, my lord.
In view of the order passed today in IAC number 2992 of 2025, the applicant shall file the corrected index of the IA in 2 sets before the registry within 2 days. whereafter registry shall do the needful. To stop, registry shall also make necessary correction in the cost in the CIS as well. List the matter again after a week. This order will be in IAC number 2586 just now. 2586 of 2025. Okay.
Yes, Your Lordship. Your Lordship, in this matter, we are about to file an implement application to implement Director of Higher Education as a party.
Okay.
But Lordship, due to some difficulties, we have not filed it yet. So Your Lordship may kindly grant us 1 week time, and in the meantime, we will file our application.
Okay, straight for a week's time is granted to the petitioner to file appropriate application seeking implement of present incumbent occupying the post of Director,
Director of Higher Education.
Higher Education. Mr. Tahivildar, your name has to be recorded. You are for which respondent? No, that is different thing. You appearing already for some already employed? Who is that? Respondent number? If it's not required to be reflected, it's okay.
Not-
I thought you might want to be your name to be reflected. Okay.
May I please, Your Lordship?
As per the last order, my lord, the review petition is supposed to place some original document before this court. My learned friend is going to make some prayer. So,
Just a minute.
28. 31/7/2025 with last order.
31/7.
Yes, my lord. Your lordship is passed, sir.
Last order is 10/9/25.
My lord, we were supposed to
My lord,
produce
but,
some original record, my lord. It's with B Kaushik, my lord. He had to leave for some medical emergency. So my lord will taken up after 1 week.
B. Kaushik, he was here just now.
Yes, I have seen also, my lord. I also met him, my lord.
He was here, but he has, due to some medical reason, he to left the court. His father-in-law taken suddenly ill.
And even, my lord, morning he said, any date fixed on 27 or 28, my lord.
So what is to be done otherwise?
Then let the fixed matter on 28, my lord.
We'll fix it, no problem. Now, what was required to be done?
The original record is to be placed as per the 31st July order, my lord.
In terms of the last court's order dated so and so has produced the meeting minutes of the. There's some overwriting the date and therefore because of.
Yes, my lord, sir.
Okay. Mr. B. Kaushik, learned counsel appearing for the
Petition.
review
Review petition.
petitioner
And I'm some respondent.
is said to have some medical emergency for which he had to leave the court early. To stop, he was required to produce the original records in terms of the court's order dated 26/2025 and 31/7/2022. To stop, as paid for on his behalf, matter stands adjourned to be listed again on
On, my lord.
when?
27th. 27th.
Okay, 27. 27.
Yes. By the Mohammed Dino.
All right, 27.
Yep, no.
October.
This case for restoration. They also did.
Who? You have filed.
Petitioner has filed this.
Or petition is filed
My lord.
for restoration and he's absent again.
Chance may be given to them now.
This application is filed seeking restoration of the writ petition was dismissed for default. Stop. However, no one appears for the applicant. Although Mr. P.K. Boral, SC Elementary is present. Forensic of Justice list the matter again after 2 weeks.
Obliged.
43, I need some time, a week's time to get the instruction losses. It is listed today after returnable dead losses. May kindly fix it as next week any dead losses.
Page 10, there was a direction for instatement to buy original goods.
How much time should you require?
Next week, losses, next week.
Next week.
I have already communicated with the DO, next week any day.
Friday next week.
Yes.
Okay.
Yeah.
That's straightforward. Mr. SMT Chisti, learned counsel for the respondent. Let the matter be listed again. On 24.
Scan ko kaya ko na
BP Bora, learned counsel. Appears for the petitioner.
Lordship, this application has been filed for a modification, Lordship, of the order dated 16/8/2023, Lordship. What happened in this case, Lordship? I am the second senior most. And Lordship, the claim of the opposite party number for provincialization of his service is on the basis of combination of subject, because he is Royal, BSc Royal. And Lordship, the opposite party number 5's claim is with regard to that he is the senior most in the school.
Okay.
Both counts, Lordship, I am entitled for provincialization.
Which
Because-
which order you want modification?
Yes,
Which order?
Lordship, 16/8/2023.
Huh?
16, Lordship, page 28,
20,
page 20,
20,
page 28,
28.
Lordship.
Modification.
Slight modification seeking leave to Lordship for my provincialization, because on both count, Lordship, I am entitled for provincialization in one of the posts. There are 2 posts of science group teacher. In one post, Lordship, I am
The
entitled.
thing is that should it not go before the appropriate bench?
Appropriate bench, Lordship.
Subject.
My senior friend's claim is on the basis of subject combination. Because if we
No,
need,
well, that is not the issue. Issue is they have gone to the tribunal without seeking sanction of the government. Under section 14, there is a requirement of taking sanction.
All right, see,
Section 19,
Mr. Chaudhary, prior to that, I was thinking,
yes.
since it's not the same court who had passed the order, will it not be appropriate to that the matter be placed before the same court? It's not a review, no doubt, but you are seeking slight modification and all that, so I don't.
Okay.
By filing this application, the applicant seeks a certain modification of the order dated 16/8/2023 passed by this court in WPC number 4387 of 2023. Stop. Considering the nature of the prayer made, it would be appropriate for the, it would be appropriate that the matter be placed before the appropriate bench. Stop. Registry shall therefore do the needful.
next. Obliged.
Petitioner number 21 had expired, my lord. We have paid for substitution, my lord. He expired in 2018, my lord. That's why, my lord, we have also filed an application for condonation of delay. Though, my lord, there is no such provision, of course, my lord. The only, my lord, bar is under section 20 with regard to filing of a contempt application within 1 year. It was filed long time back. But in the meanwhile, he expired, my lord, petition number 21. We are paying for substitution of petition number 21 with his legal heirs, with his wife and Millard's son, my lord.
You are the petitioner.
I am for the one of the petitioner, my lord, because there were 29 petitioners here. One of them are expired, my lord. Initially in the contempt period, there are 21 petitioners, 29. One petition number 21 had expired, my lord. I am for the applicant, my lord, the wife and my lord, the son, my lord. Now,
When did,
he expired in 2018, my lord, but she was not aware of this proceeding, my lord. On 13/10/2018, she expired, my lord.
okay, in such a situation, what is required to be done?
Well, I have filed, that's why I filed an application for condonation of delay also, my lord, as an abandoned caution.
Delay was condoned?
No, my lord, this has come for the first time.
Oh, this is a condonation.
Yes, madam. Condonation is 3040. Because, my lord, the registry, my lord, raised an objection saying that we should file an application for condonation also.
But both are marked as condonation. This is also condonation.
One is, my lord, for substitution.
Which one is condonation? Tell me.
Condonation, my lord, is, my lord, 3040.
This is, both files have given me, same file. This is also 3040, this is also 304.
Huh?
I'm sorry, 3034. Okay, sorry.
3034 is the, my lord, substitution application.
I see.
And, my lord,
3040 is a condonation.
3040 is condonation, madam.
Who's appearing already?
Well, my lord, it's fairly appears, man. Okay, go ahead.
You are appearing for which respondent?
Lordship, in this
4 and 5.
70, it is 70, 18, isn't it?
Yes, yes.
Yeah, 17, 18, I am appearing for lordship of 4 and 5. One
1718 means, what do you mean 1718?
70, 2000, oblique 2018 is
Oh,
a.
70,
Contempt case of 70 of them.
It's a main case, contempt case.
okay.
But in IL lordship, so it is for first time. Notice should go.
Pritam Saikia is there.
Pitam Sage is no longer holding the post. Or Nayanpur has already been.
Then you are appearing for whom? By name, by name,
Main case lordship, I am
Ba-
appearing for
by name.
Resolution 5.
No, here the opposite by 6 and 7, Suranjana Senapati and Narayan Kumar. madam.
It could be case.
Same case, yeah. Yes, the opposite party 6 and 7 করা আছে.
So issue notice
So
that.
it will 4 and
Yes,
5.
lordship may
Four
have
and
issue notice. This.
My learned friend is appearing, my lord, he'll accept the notice. Since he's appearing, my lord, he can accept the notice.
Yes,
to
yes,
respond 4 and 5. 4 and 5.
4 and 5.
4 and 5.
4 and 5.
4 and 5.
They are the present.
The director and second.
But where is 4 and 5?
But in the cost title, it is shown as 4 and 5.
My lord, I think, my lord,
You have skipped from 3 to
yes,
6.
my lord, the numbering has been a mistake. The mistake in numbering, my lord. It's actually.
But in the cost title, it is correctly shown 4 and 5. As in,
Which course title?
in the website,
From 3, my lord, 4 and 5, my lord, typing mistake, 6 and 7.
No, here in the cost title in the copy, it's 1, 2, 3, then it goes to 6 and
6
7.
and 7, that's a mistake, man.
that's a mistake.
But my lord, in the my lord, original part, my lord, page 6, my lord, that you will find.
So you are appearing by name for Suranjana Senapati
And Narayan.
Narayanpur.
and Narayan Kuwar.
Yes, I have 5 local also.
So should I say 6 and 7?
No, 4 and
No,
5,
no,
because
4 and 5,
but
no.
page 6 is correctly
It will be
depicted.
4 and 5.
Page
Huh?
6, my lord, page 6, it is correctly depicted, man. 4 and 5, man. Page 6, man.
Okay. At Mr. M. Datta, learned counsel for the applicant. This will be in IA 3040. M. Datta for the applicants.
Applicants.
Who submits that by filing this application, the applicant seeks completement of the legal heirs of petition number 21 in the contempt petition.
Rajendra Kumar Dekaman.
Who expired on 13/10/2018. So we submit that instead of the original petitioner number 21. Where are the names?
My lord, page 7, my lord.
Hmm. The names Srimati Mandira Deka and Sri Nituraj Kashyap may be incorporated as respondent numbers.
No, as a
Petitioner.
Sorry, petition numbers 21
A and B.
capital A and 21 capital B respectively. Since they are the legal heirs of the original petition number 21. Next para, issue notice, returnable by 3 weeks. Mr. SMT Chisti, Learned Counsel appears for the respondent numbers
4 and 5.
4 and 5. That is Dr. Bijoya Chaudhary
No, no.
and, okay.
Four.
Huh? Sorry, that is Dr. Suranjana Sinapati and Sri Narayan Konova, respectively. Stop. As such, no formal notice is required. Petitioner shall furnish requisite copies to Mr. SMT Chisti within 2 days. Then what about the others then?
Others, my lord. Others will come along with lordship. Because my lord, they are no longer there, my lord, because they've since they are originally in the error parties. My lord.
List again after 3 weeks.
Yes, oblige your lord, oblige.
And your lordship, before submitting, I have a prayer, my lord. In this matter, my lord, honorable court had directed to file an affidavit, my lord. But he is not available today, my lord, whether he is filed or not, that instruction not available with me, my
You are appearing for whom?
elementary department.
Huh?
Elementary department.
Elementary department.
Yes, ma'am.
Who are the respondents? Number? Director, District Elementary and Block Elementary, then Commissioner. Also,
My lord, I have submission in this case.
are you appearing for 1, for 3, 4, 5?
Yes, madam, already responded.
Number 2 is finance.
Yes, yes.
Hmm.
1, 3, 4, and 5, madam.
Okay, so what are you submitting? I
Actually, in this matter, madam, my colleague F1 have received the instruction
Oh.
and accordingly supposed to he file an affidavit. He will file an affidavit, but he is not available today, madam. I don't, madam, whether he had filed or not, the affidavit, that instruction not available with me, madam. And
You should
madam,
have-
as per records, no.
You should have checked the records if that information was available to you. You could have. You are appearing on behalf of Mr. Fukan.
Yes.
Then you should have checked up. But no affidavit, give me some time like that. I'll check it up for you, don't worry.
My lord, I have,
It is not.
Leave it to the court
I have
to take up
submitted.
everything. Affidavit is filed, director has filed. Then director has filed, then the reply also, no. Yes,
My lord, originally, we were appointed, two items are together. We were appointed in the year 1994.
Hmm.
Then, my lord, there were a large number of inquiries held. Then finally, the director provincialized the services of these persons. Kindly see page 16. Page 16 is the provincialization order
And here, my lord, my name appears at serial number 118, page 20. Almost all the teachers have already received their salaries. Even this 123, serial number 123, Tulsi Bourbon, he has also received his salary. And that I have annexed here. That order has been annexed. So we were provincialized in the year 2006 by the director, and till today we have got nothing. And the another item number, next item number, Hafizur Rahman,
This is for area salaries.
area salary as well as current salaries, we are getting nothing
Okay, area and current salaries.
Yes.
You're working as what?
as an LP school teacher.
LP school teacher?
Yes.
Okay.
So since 2006,
The other case also same.
no, other case, my lord, since November 21, he is getting salary. Monthly salary, not
Then-
arrears.
He's getting salary, so why did you file the writ petition then?
No, no. I have not this, no, at that time when this case was filed, at that time, it was under process. But in the year 2021, he filed the, he started getting salaries from November 21. Hafizur Rahman, next item. And this item, Solimuddin, he has got nothing since the year 2006 till today. Not even the current salary.
Okay.
They have taken dates after dates after dates, they will do that, and nothing is done.
So the present case, item number 18. 18 is for area and current salaries.
Yes. Number to go. 18, yes.
18,
18,
Solimuddin.
yes. And
This is for area and current salaries.
current salaries.
And the other one, item 19,
19.
Hafizur Rahman is for,
He is getting salaries from November 21 till today.
and prior to 21,
No, he has not got.
no claim.
Not.
You have-
No, we have claimed.
You have claim.
We have claimed, but we have
Okay.
not got.
Okay, so that means that case is regarding area.
Yes,
The present case is regarding area as well as current.
yes.
Okay.
Since
And
2006.
they have filed an affidavit. Are you not filing a reply?
No, my lord, kindly see your order dated 69/24 month. This affidavit is not filed. 69/24 month.
6. That order is regarding the other case,
Yes, ma'am.
6786.
To file our affidavit. As per this order, if one has received the instruction, but today he is not available to me.
Why is not available?
Due to some personal difficulty, he is out. of
There has to be
station.
some reason, you see.
Yes, ma'am. So kindly sometime will be allowed.
Since
As
2006,
per the office record, he is
they
not
are-
filed, ma'am.
in difficulty, since 2006. It is very pathetic that since 2006, in spite of provincializing our post by the director, we have been paid nothing. We means Solimuddin. So if my learned friend is on seeking adjournment, then at least current salary may be paid to
No,
me.
my lord.
It's Solimuddin.
Please write down. Although Mr. A. Fukan Lanet, Standing Council Elementary Education, submitted on 16/9/2024 that he has received instructions in WPC number 6786 of 2017 and sought for 2 weeks' time to file affidavit. comma, no affidavit has been filed till date. Full stop. It is seen that the respondent number 3, director,
Page 16.
elementary education has filed affidavit in WPC number 7058 of 2015. Full stop. Mr. A. Fukan, on account of personal difficulty, is said to be not available today. Mr. Review of above, let the matter be listed after 2 weeks.
Current salary may be paid. Since 2006,
I don't know what.
Uh,
no, kindly consider, since 2006, even after provincialization, we have not received salaries. So it is very pathetic.
No, my lord. Kindly sometime in there, because I don't know.
It is their officer's order, my lord. It is their officer's order.
Give a date, list the matter on so. 4/11. The learned standing council elementary education shall ensure that affidavit is filed on or before the next date, so that the matter can be taken up for final disposal.
In both the cases.
This is a common order for both the case.
Lordship, can it be taken after some time? After some time, Lordship.
May it be pleases your lordship. Pertaining to this matter, your lordship, I may grant it 2 weeks further time, your lordship, to obtain instruction. Instruction is still awaited, not received.
2021 matter,
Yes, Lordship.
why you are not receiving instructions till now?
Lordship, this pertaining to 21 matter, your lordship, we have lost the file, your lordship. We are not able to trace the file, your lordship. So we have to reconstruct the file.
Anything else?
Second.
You have not received instructions, number 1. Number 2, you have lost the file. Any other ground?
No, your lordship, but today we will reconstruct it, your lordship. And will, your lordship, obtain it, your lordship, try to obtain.
What is the case regarding?
It's regarding
Area
for
salary.
payment of area salary.
That is salary. Ms. P. Das, Learned Standing Council, Secondary Education submits that the case brief has been misplaced and she may be given some time to reconstruct the same and file
Kumar, here you go.
counter affidavit. Considering the submission that the matter be listed again after 3 weeks on so and so, give a date. 18/11. The Learned Standing Council shall ensure that counter affidavit is filed on or before the next date, having regard to the fact that the matter is of the year 2021. Okay. List accordingly.
Much obliged.
Deeply obliged.
May it please your lordship. My lord, this petitioner, my lord, he was pursuing his studies in IIT Guwahati, my lord.
Mm,
There was an unfortunate incident
mm,
which happened in 2021, my lord.
Hmm.
Because of that, initially his studentship was suspended.
Hmm.
Subsequently, my lord,
Hmm.
his studentship was terminated. Now, my lord, there were police case also. But the punishment which has been imposed, that is not on account of the police case, but on account of indiscipline. In fact, he was found taking alcohol within the campus with a girl student. And it so happened that the girl student lost consciousness for some time. She had to be hospitalized. Then there were police case. There was some allegation regarding sexual assault and all. Those were proved to be wrong. Anyway, those were not taken note of. Now, if your lordships would kindly come to page number 178. My lord, what I will submit for your lordship's kind consideration is,
Just a minute. Switch off this thing. The other way, the other part. No, no, no. It is separate. Okay. Life is there. It's only for me. It is only for me. Then it is only the gain out of thing, right? Yes, Mr.
yes, my lord, a show cause notice was issued to him, which your lordships will find at page 178. But I'll have your lordship's kind attention to page 180.
Who's for the other side?
My lord.
All the respondents?
Yes. IIT Guwahati, my lord.
Union of India is separate.
IIT Guwahati.
Yes. Now at page 180, my lord, the various, wrong committed by the 180.
180.
Yes. Violation of any published IITG Guwahati policy rules regulation. It is responsibility of the students to be familiar with IITG policies that refer to appropriate behavior on campus. Ragging in any form is prohibited in the premises of IIT Guwahati. Violation of IIT policies causing threat to academic integrity, disorderly conduct, including but not limited to verbal abuse or inappropriate misbehavior on any other activity or behavior, physical abuse, including but not limited to inflicting or threatening bodily harm. Now, 3.2M, drinking, alcohol and use of drug are strictly prohibited in all residential facilities. In addition, no alcoholic beverages are permitted in facilities designated as substance-free. Drunkenness will not be tolerated, and students found in drunken state may face expulsion from residence of hostels. Influencing or attempting to influence another person to commit an abuse of the code and conduct of the student system. Therefore, you are called upon to show cause as to why proper disciplinary proceeding should not be initiated against you for committing the above mentioned gross misconduct, which have resulted in committing violation of the above mentioned clauses, ordinance on code and conduct of student, which is unbecoming of a student of IIT Guwahati in terms of ordinance on code and conduct of student, and further as to why disciplinary sanctions should not be imposed upon you as per Rule 5 of the so-and-so. Now, pursuant to this, my lord, if your lordships would kindly come to page number 282. In between, certain developments were there, but for the purpose of the prayer which I will be making, my lord, I think these facts are good enough. Page 282, my lord. What I prayed for, my lord, please provide me the following references mentioned in your termination letter. Senate resolution dated 11/2/22, recommendation of students disciplinary committee meeting, so and so. So, my lord, these were provided to me. Then eventually at page number 283, on the strength of the Senate resolution and the recommendation of the Student Disciplinary Committee, with reference to the subject mentioned above, and based on the recommendation of the Student Disciplinary Committee, the Senate-wide so-and-so resolved to approve termination of a studentship from the institute with immediate effect. Now, my lord will kindly mark the date, my lord. It was on 7th of March 2022. I have already lost three valuable years, my lord. Otherwise, I'm a brilliant student. Now, the only prayer I'm making at this stage is, my lord, I think for drinking alcohol within this, campus, my lord, he has suffered enough and enough. In any case, my lord, my humble submission is the punishment is disproportionate, my lord. I'm not troubling your lordships with my misconduct. Yes, it was there. I should not have taken and consumed alcohol within the campus, and that too with girl students and all. These are there. And the police case and all were there, but those were not taken note of by the authority while punishing me. Now, my lord, I should be allowed to complete my course, my lord. That is my only prayer. Some humanitarian approach is required, my lord. And I have already suffered 3 years. I think that is good enough a punishment.
You had just read 283.
Yes, my lord.
Based on the recommendation of
Yes,
the
those recommendations are there, my lord. I can place those. Yes.
resolve to approve the
Yes.
termination
Yes.
of your studentship. Then with immediate effect.
Yes.
This was in 7/3/2022.
2.
And prior to that, you had shown me 282.
Yes.
This
Now,
was,
if your lordship kindly takes their affidavit, my lord, there the SDC committee and the, my lord, the Senate proceedings are there.
no, Mr. Chaudhary, see, after approval, you're asking for the documents.
No, my lord, I'm not troubling your lordships, all those technical
No,
aspects.
no,
The
I'm
fact
just-
of the- oh, acha,
I'm just indicating the sequence.
okay. Sequence is, my lord,
The
earlier
sequence-
there was a termination order at page 154. That's why, my lord.
No, what I'm saying,
Earlier, no, my lord.
only
pa-
282 and 283.
No, my lord. Before that, at page 154, there was a termination order. There I said that you have relied upon so and so,
Hmm.
but you have not given me these two. That is how. Page 154, my lord.
This is also again email.
Huh.
It's email, is it?
Yes.
Dated 17/9/21.
Yes. As directed, please find attached herewith letter regarding your termination from institute with immediate effect. That order is at next page, my lord.
Hmm.
Based on the recommendation of the Student Disciplinary Committee and resolution of the Senate-wide resolution dated so and so, in connection with your involvement in the incident of March 28, you are hereby informed that you have been terminated from the institute. Then I wrote that letter, my lord. That is how it was given to me. Then again an order passed. Earlier I approached this honorable court also, my lord. This honorable court also said, by interfering with the earlier order, then the liberty was given to them to proceed in accordance with law. Earlier there was an order.
This is the order.
This is the order.
Then you came to the court.
Yes, at page 156.
Then court,
Then they provided me the two committees, my lord. Court's order is at page 156. And 157 is the order. RP Kakoti Lanet Senior Counsel for Respondents in the IIT upon instruction has made a statement that authorities in IIT would like to proceed against the petitioner by giving adequate opportunity as required under the law. In view of such statement, it is to be understood that impugn order of termination would not be acted upon. However, it would be open for the respondent IIT to proceed in any manner by following any procedure and any requirement as may be available under the law. In view of such statement, this writ petition stands closed. Thereafter, my lord, this process was undertaken. Show cause notice was issued, then those two reports were given.
but you are already terminated.
Yes.
Page 155.
Yes, I have been terminated, my lord. That's why I have challenged this. Otherwise also, my lord, there are procedural improprieties. I'm not even troubling your lordship with all those finer details, my lord. Regarding the, my lord, student disciplinary committee and senate that they have annexed in their affidavit. If your lordship would kindly like to have a look at it. That is at page number 61. Of the affidavit.
Affidavit.
Affidavit filed by IIT, my lord.
60.
I'm sorry, my lord, that running pagination was not there because this matter was heard and kept preserved for quite some times, for more than 1.5 years.
15, page 59.
Page 61 is the relevant portion of the affidavit.
Page 61.
Yes, my lord, of the affidavit.
Rejoin the.
Deliberations at page 61.
Yes, deliberations.
Yes. The SDC deliberated on the matter of Utsav Uday Kadam based on interaction with students involved in the case. The SDC carried out extensive investigation of the incident related to Finance and Economic Club meeting held on 28th of March. The SDC considers this to be a case of ragging, substance abuse, drinking, and negligence leading to victim falling unconscious at the old Akshara school within the institute premises. Since the case of old Akshara school is sub judice and is not under purview of the SDC did not deliberate on the matter, which is sub judice. The SDC only deliberated on the matter of gross indiscipline perpetrated by Utsav Uday Kadam on junior students in the FEC meeting at so-and-so. Then, my lord, in the next page, they have taken note of this clause 3.2.m. Drinking alcohol and use of drug are strictly prohibited in all residential facilities. In addition, no alcoholic beverages are permitted in facilities designated as substance-free. Drunkenness will not be tolerated, and students found in drunken state may face expulsion from the residence school hostels. Recommendation. Based on the above deliberation, SDC recommends termination of studentship of Utsav Kadam. Then, my lord, based on this, the Senate at page 74 page 74, the proceedings of the Senate starts, my lord, and the operative portion is at page 78.
Of the affidavit.
Page 78.
Of the affidavit.
Yes, my lord. Yes. That is the proceedings of the Senate, where, my lord, the SDC recommendation was accepted and pursuant to which the termination was effected. Future course of action for Utsav Uday Kadam. The chairman Senate briefed the Senate about the background of this agenda item. The chairman Senate reiterated that the institute was deeply concerned about such untoward incident, which were serious violation of the code of conduct of the institute, and IIT Guwahati strongly condemned such incident. The associate dean, student affairs, to brief the Senate about the unfortunate incident that happened on the night of 28th of March in the campus. She chronologically narrated the event and informed about action taken by the institute in this case so far. She apprised the members of the steps taken by the institute to support the victim and also informed about additional measures taken by the institute specifically for safety and security of women in the campus. The Dean of Student Affairs briefed the Senate about the sequence of events related to sexual abuse of the case involving Utsav Uday Kadam on the night of so-and-so, leading to his arrest and suspension by the institute on 4/4/21. Kadam has been granted bail by the Honorable Guwahati High Court by its order dated 13/8/21. The court in its order stated that there were clear prima facie case against the accused petitioner and investigation is was completed. DOSA informed that with due legal vetting, the institute was considering future course of action in this case. He adopted the Senate about the final recommendation of the Students Disciplinary Committee held on so to terminate Utsav Uday Kadam from the institute with immediate effect. The Senate deliberated on the matter at length and was of the opinion that the case was a serious violation of the Code of Conduct and highly deplorable. Senate members strongly condemned the incident and opined that reported acts of gross indiscipline perpetrated by the accused, vomiting in the students' code of violating students' code of conduct has to be strictly dealt with by the institute. The Senate was unanimous that it was necessary to confer exemplary punishment on the offender and the institute could not compromise on the safety of women in the campus. The members offered a few suggestions for augmenting security measures for women in the campus. Members highlighted the need to sensitize the students about conduct rules and gave consequences in case these are violated. Senate upheld the recommendation of SDC to terminate Utsav Uday Kadam from the institute with immediate effect. Now, Milord, there is a slight factual, clarification is required, Milord. What had happened on 28/3/21, this petitioner and one girl student, Milord, they consumed liquor within the campus. Now, actually, there was some internal election where that girl was elected. Then she became a joint secretary of that student unit. In any case, both of them drank. Thereafter, Milord, she lost her consciousness. There was some confusion as to what had happened. Then she was taken to Guwahati Medical College Hospital. Now, Milord, somebody felt maybe it could be a case of sexual abuse, etc., etc. So therefore, Milord, the criminal investigation progressed. Now, ultimately, Milord, the SDC and the Student Disciplinary Committee and the, Senate, they did not took note of that incident. On the contrary, they took note of the incident of, Milord, drinking inside the campus, and that too with a girl student. Anyway, Milord, medical examinations were done, nothing, there was the sexual abuse and all these were not proved. That is not even the subject matter of controversy also. Now, Milord, my humble submission is twofold. Yes, I committed some omission and commission, Milord, for which I have already suffered serious punishment, Milord, of loss of 3 academic years. Now, secondly, Milord, if your lordship should kindly have this page 78, how can this be a relevant consideration? Please come to page 78. The last but one para, the 4th line. The court in its order, page 78, Milord, page 78 of the affidavit. The penultimate paragraph, 4th line from the top. The court in the order stated, has your lordship got it, Milord? 4th line, the Dean of Student Affairs, DOASA, sentence starting with that. Page number 78, 2nd para.
Yes, Dean of Students.
Yes. Please come to 4th sentence. The court in the order stated that there was a prima facie case against the accused petitioner and investigation of the case was completed. My lord, this was a finding given in the bail application. How can this be a material to punish somebody, my lord? In any case, my lord, is it not a case where the punishment is highly disproportionate, my lord? And the others who were dealt with were leniently, my lord. Now, there is one more problem. As an academic institute, I do appreciate the girl victim, my lord, at the relevant point of time, she was also studying. Now she has passed out. She is no longer there. So his admission into the institute is not going to cause embarrassment to that girl student. Am I clear to your lordship, my lord? Now, all that I want to say is, number one, it is a very harsh punishment. And secondly, this observation of was taken note of at it prima facie looks like, my lord, then it was wrong. Because an observation made in a bail order, it cannot form basis for, or it will not furnish a cause of action to take a disciplinary action.
This bail order is there in this?
No, my lord, this is the observation. They say, my lord, the sentence before that, Kodam has been granted bail by the Honorable Guwahati High Court by its order dated 13/8/21. Court in its order stated that there was a clear prima facie case. So based on case study, this observation was made. Now, my lord, number one, the girl student is no longer there. I can appreciate at the relevant point of time. We do not know, my lord, if the matter would have been, the judgment would have been delivered, or what would have been the outcome. But assuming, my lord, the judgment would have gone in my favor, then it could be a case where there could be some cause of embarrassment for the girl student. Now she has passed out, she is no longer there. So all that praying is, my lord, I should be allowed to enter in the exams and pass out, my lord. Otherwise, I have a good career ahead, my lord. Otherwise, I'll be doomed. Therefore, in the ultimate analysis, I was found guilty of consuming alcohol within the campus. For that, should my studentship should be, my lord, terminated. The prima facie, my lord, it appears to be very harsh and disproportionate. Possibly, my lord, the institute would now like to take a lenient view, my lord. Earlier, that lady student was there. Things were different. This is the background, my lord.
Okay. What you just read out is the minutes of the Senate.
Yes, based on which the impugn order is passed.
That order has been looked at subsequently. Another order was passed. This was called back. This order is called back. After this honorable court directed the IIT, and we also said that give some opportunity to the boy to give a so-called notice, opportunities, give him a hearing. All this was done to do all these things that Senate, that the order that was shown to your lordship, that has been called up. And subsequently matter was, after all these things have been done, the order 141, this was passed by the Senate, and this is the impugn order at page 140. Page 140, the,
No, order of this court is dated.
this is,
Yes, I'm giving, my lord. Order of this honorable court is at, one second, page number 156. Ah. 7/10/21.
And this Senate's meeting is
Was 6/9.
6/9/21. So after the order of this court, what happened?
After the, my lord, that order at page number 152, sorry, order at 282. Show cause notices were there. Show cause reply was there. Then at page 282.
No, 282 is your letter.
Eventually, the final order of my lord.
No.
Termination.
282 is that please provide me the following materials.
No, page 283.
Yes, 283 says on the recommendation of students discipline committee.
Yes. So, with
11 to
references are based on recommendation of so and so, resolve to approve termination of your students.
So where is this 11/2/2022?
That, my lord, that record.
11 to, that is on page 140, lordship. One of the counter affidavit, 140 of the counter affidavit.
140.
Lordship, this is that earlier proceedings were dropped. It has been started afresh.
I'm sorry.
That
Yes,
is in the
yes,
notice.
yes. I think the relevant portion is at 142, my lord.
141, we start from 141, lordship.
No, I think the relevant portion is at 142.
Item number?
142, my lord, on second para on 142.
Item number 12.
It comes under item number 12.
12. Please come to page 142. That's the operative portion. The Senate considered the matter and deliberated at length. as the matter of sexual assault is sub judice, Senate agrees that no action can be considered on that ground. However, the Senate noted that recommendation of SDC are clearly based on gross indiscipline of Utsav Uday Kadam on the charge contained in the ordinance of court and conduct, but not a sexual assault. Accordingly, Senate unanimously accepted the recommendation of the SDC and opined that the studentship of so and so be terminated with immediate effect. So that incident of that Milord sexual etc. was not considered. It was based on disciplinary ground, Milord, that the studentship
Okay,
was.
now where's the recommendation of the SDC?
Recommendation of the SDC is at Milord page number 61. The operative portion is at page 62. 69 Niki? 59.
59.
59.
59.
Yes, at page 62, Milord. 3.2.m, drinking alcohol and use of drug are strictly prohibited in all residential facilities. In addition, no alcoholic beverages are permitted in facilities designated as substance free. Drunkenness will not be tolerated, and students found in drunken state may face expulsion from the residence hostels. As the also deliberate opinion of legal retainer, etc., then recommendation. Based on all above deliberation, SDC recommends termination of studentship of Utsav Uday Kadam from the institute with immediate effect till finalization of the criminal case instituted against him.
So what has happened to the criminal case? Anyway, you see, both the
SDC and the
the Senate's resolution are based on the SDC.
Yes.
SDC dated 3/9/21.
And there is another one at page 92.
That is the final one, because
Final one.
after giving you all opportunities, matter was reconsidered.
They have reiterated, Miller.
No, I understand. See, but first of all, the Senate, the SDC met, then Senate took a decision that we accept the SDCs.
Yes, yes.
Then writ petition was filed, court, and in the midst of the pendency, the respondents decided to give him a chance. Chance was given. Again, the Senate sat and said, we accept as the report.
Again, first SDC said, then Senate. That is
They
at-
repeated again.
Yes, page 92 of the affidavit.
This is the final order of the SDC, Lordship, report of the SDC. Very, very soon.
Now, please come to the last para at page 92. The committee observed that being a senior student and holding a position in FEC club, it was irresponsible on his part to consume alcohol within the institute premise. Further, instead of reprimanding the junior female student for her suggestion to consume alcohol together, he too supported her and involved in act with her. Further, after hearing his version, SDC opined that Utsav had deliberately delayed in seeking medical assistance for female student despite her unconscious state and neglected to inform the matter to the institute authorities, etc., etc. So and so. Utsav holding her hair and dragging the female, actually after interacting with Utsav Kadam, the SDC could not find any merit justification for revisiting earlier recommendation of termination of studentship of Utsav Kadam. In the above context, SDC of the opinion, the following clauses of ordinance on code of conduct stands so and so. So they reiterated the recommendation as we find in page 62. So therefore, my humble submission is, my lord, I have already suffered a lot. Now I should be allowed to complete my course, my lord, showing some leniency.
What is the course?
It's an IIT, my lord. It's chemical. No?
Duration of?
4.5 years.
And he was in which semester?
1.5 year.
He had done just 1.5 year.
He was in the second year, the girl was in the first year.
And my lord, that girl is no longer there.
It's not, she's not there now. She has passed out and left the campus. So that is a position, Lord. This we have filed our written arguments also, the petition also filed, we have also filed. That aspect of order proportional response that lordship will consider that. I'll not give you my view on that. Otherwise, the matter was really serious. If the lordship wants to know about it, how grave serious it was, but that's what the lordship does. I don't want to go.
No, I've heard Mr. Chaudhary now the 5-10 minutes
Yeah, lordship.
and you are yet to submit. So how do we decide like that? If you concede that, okay, we'll allow him to continue, but hence we don't
That
look
would
into many
also be-
things.
Issue a
But if you say that this is very serious and we stand by
Yes.
what we do, then we'll have to,
But,
I'll have to examine this aspect and decide.
that's the matter is very serious, but now the girl, as I said, my learned friend, the girl has passed up to the campus and boy has also lost 3 years. That aspect, the lordship will consider. I shall not get.
Milord, I may
not
indicate,
make-
Milord, I may indicate,
Both parties are giving me some indications, I understand.
Milord,
But the
what
thing is
I,
that,
Milord, what my, from taking a cue from my learned
Hmm.
senior friend, Milord, what I submit is, at that point of time, I was given to understand that permitting you to resume your studentship would be an embarrassment to the girl.
where is
Huh?
that?
No, she's no longer there, that female
No, that
student.
particular
No,
stand.
because that was, this not been written, Milord, but it was given to understand. Now the fact
No,
that,
did anything happen between them?
no, nothing.
Then what embarrassment will be there?
The embarrassing was, Milord, a police case was filed as if it is a case of sexual assault because she was unconscious for about 2.5 hours. Actually,
No,
after
yeah.
consuming liquor, Milord, she became
It's
unconscious.
not that simple, lordship. Well, if necessary, I'll go to the facts and place it, the fact finding report, first finding report, very serious. But I'll not go to that now.
That's one.
So now the
So,
question is,
so I would request the parties to address the court accordingly. But if it's like, if the parties agree that something can be done, then you tell me straight away, either we will pass the necessary order. But if you say that this is very serious and on that context, the court has to consider.
that's a different aspect. Now, this lordship says, lordship will give a direction to the parties in that case. Lordship may issue a direction to the parties, whether matter can be reconsidered and lenient view can be taken.
Yes, that can be, it
If the
can be
lordship
disposed
issues a
of. with
direct
that.
order,
What about mediation then?
mediation
go for
of the
mediation.
child is gone now.
Huh?
The affected victim,
She's
she has
no longer
left-
there.
she left
No,
the campus.
victim is a party here.
No,
No,
she's not a party
then
here. Now,
It
the
is
party
between the
that-
petitioner who has been,
Whose
No, like-
studentship has been terminated.
whose studentship has been terminated and is
submit
between
a
the IIT.
representation to the IIT that to consider him leniently taking.
So that's
back.
why if you sit together and consider, okay, we take you back subject to you signing a bond or whatnot,
Mhm.
mediation, finish.
That
If
can
that
be-
cannot be done, then we'll have to decide on the merit.
That of course.
And
lordship
for that,
will say
you-
that will be-
at least you'll have to
that
address
will be
For the
attempt-
rest of my tenure, I will maintain proper conduct, discipline and all. That instruction my learned friend can take, Milord.
Or lordship may direct him to approach the Mali representative IIT because time has changed, situation has changed, environment has changed. So they can make an
I
representation.
understand, but I don't know.
So let IIT consider the representations.
See,
Or the direct
such things can be done, but whether it will be workable or not, it'll entirely depend upon the council also. How you advise your clients.
So once the order is passed, they will definitely seek our advices or size instruction. If the order is passed by lordship, then definitely our instruction be, our advices will be sought for.
My lord can close this petition, observing that I'll approach the authority. And authority will consider it, taking note of humanitarian consideration, because I've already suffered 3 years. I think that itself is a good, huge punishment. 3 valuable years in a student's life. And the action, the misconduct was consuming alcohol in the campus.
That we shall not go with that, but lordship may issue a direction to him to file a representation. IIT will consider it on.
He had just read out, where's that? Page 180.
Yes, Milord.
1, 2, 3, 4, 5, 6, 7 points. Show cause notice.
Yes. 180, Milord.
180.
which resulted in committing violation of the above mentioned clauses, ordinance and code of so-and-so, which is unbecoming of IIT Guwahati in terms of so-and-so, so-and-so. And further, as to why disciplinary sanctions should not be imposed upon you as per Rule 5 of the so-and-so.
So this is the ordinance and code of conduct of students.
Yes.
Clause.
Rule 5.
Is this an abstract of the ordinance? Page 180?
No, Miller.
3.1
Yes, that within the bracket is yes.
3.12,
Yes.
3.14.
These are the relevant misconducts.
And where is it shown what he has done? Oh, you are involved.
Yes.
That is the.
No, Miller,
Yes, in-
because they have taken note of that SDC minus Miller. Basically 3.2.m. That consuming liquor, alcohol.
What happened first was the SDC,
Yes.
then the notice,
Yes.
then the Senate.
Yes. No. First, Millard SDC, then Senate, then show cause notice. No, initially there was no show cause notice. I was straight away terminated. Then I filed the writ petition. Honorable High Court, this Honorable Court said, no, you must follow some procedure. Then the SDC took up the matter. Then thereafter it was sent to the show cause notice was issued. Show cause reply was filed. Then Millard,
You are
the
also
matter
hard-
was referred to the Senate, and Senate took the call based on which the impugned order at page 283 was passed. I think, Millard, I have suffered enough punishment
Mhm. What
for
is this?
consuming liquor.
Uh, What is this, page 74? This is
Of the writ
Some-
petition, Millard.
some deposition.
Yes. And this is the deposition of the doctor, Millard. Kindly see, Millard, that's a very damaging for the institute, Millard. If you kindly come to the last sentence at page 74, the hymen had all tears at 3, 5, 7 and 11 o'clock position. So therefore, Millard, the girl was used to intercourse. The last 4 lines. On the basis of physical examination done on this is the doctor's view, Millard, statement under 164. It was hereby opined that vaginal smear does not show presence of so-and-so and so-and-so. An opinion regarding recent sexual intercourse is kept pending till receipt of the report from DFSL.
This is the
Kalipara.
criminal side.
No, that is on the other. But then, Millard, there was no FSL report also did not support. Everybody proceeded on the basis, Millard, because after consuming liquor, something happened. But there is no material to suggest. That's why they rightly did not take note of all these allegations.
No, the criminal side, we have not taken note of.
And
And the
criminal trial, I'm sure, Millard, there will be an rank acquittal in this case.
Okay, we'll write a short order then.
Yes,
Tell me the facts.
yes.
We'll go slow. Alright, Mr. K.N. Chaudhary, Learned Senior Counsel, assisted by Mr.
Mr. P. Gayon.
P. Gayan for the petitioner. And
RP Kakoti Lodge.
Mr. R.P. Kakoti,
Lodge.
Learned Standing Counsel,
Lodge.
IIT,
IIT Lodge.
for all the respondents.
All responsibilities.
2 to 7,
2 to 7.
except in
Number 1 is the Union of India, 2 to 7.
Except respondent number 1.
Mr. Day at SSP Lodge. Mr. AB Day.
Okay, Kakoti assisted by Mr. A.B. Day.
Lodge.
Next para, this is the second time the petition is before this court. Stop the earlier writ petition being WPC number 5354 of 2021 was disposed of on 7/10/2021. After the Learned Standing Council, IIT made a submission that the authorities in the IIT would afford an opportunity to the petitioner before arriving at a conclusion as to whether his studentship in the IIT should be retained or otherwise. Stop, next para. From the above, it may be seen that the petitioner had enrolled himself as a student in the IIT Guwahati. And at the relevant time, he was a third-year student undergoing the 6th semester course. Undergoing his and was in the 6th semester. Full stop. According to the petitioner, on 28/3/2021, he had consumed liquor along with one junior colleague. Whereafter, the junior colleague became unconscious and had to be hospitalized. Stop following the same, 3 FIRs were lodged and later amalgamated into one. He was arrested.
Yes, he was arrested.
The petitioner was arrested as a result of lodging of the FIR, but was later released on bail. Stop, the IIT authorities. Where is the termination? The first, the
Yes,
dispensation of the,
first termination is at page 154. Rather at page 155 below.
on the basis of the recommendation made by the Students Disciplinary Committee, bracket SDC, followed by a resolution taken by the Senate, terminated the studentship of the petitioner with immediate effect by communication dated 16/9/2021 made to the petitioner. Stop, agreed with the same. The first writ petition was filed, which however came to be disposed of since the IIT authorities decided to give the petitioner an opportunity to be heard on the matter, as already indicated herein before. Then what happened?
Then, my lord,
It's given a show cause notice day after.
Next paragraph. Subsequent thereto, the petitioner was given a show cause notice on 21/12/2021.
To which the petitioner replied on, my lord, 27/12/21. At page 212.
Informing him that he had violated the ordinance and code of conduct of students of IIT. And therefore, why he should therefore not be proceeded against. Then the petitioner was also furnished with a copy of the fact-finding committee report, minutes of the SDC meetings, and the ordinance and conduct of and the ordinance and code of conduct of students, IIT, amongst others. Where is the reply?
Reply is at page 212, my lord.
So the petitioner responded to the show cause notice by submitting a reply on 27/12/2021.
At page 217, para 9 may be perused, my lord.
Stating the facts of the case while accepting the fact that consumption of alcohol within the campus of the IIT was not permissible. Stop. He further indicated that for his action, he had already undergone he had already paid a heavy price for not being able to continue with the course to which he was admitted, while assuring that he would not repeat similar act in future. Stop. He thus sought for favorable consideration and permission to continue with his studies in the institute. Then the next
Then, my lord, the page 92 of the affidavit,
92.
the student disciplinary committee on 24/1/22.
Hearing.
This happened after the disposal of the just a minute, where was the notice?
No, my lord, the notice was, the reply was 27/12/21. And
Okay,
hearing also took
Okay.
place 24/1, my lord, at page 92 of the affidavit.
prior to this, there was a hearing.
Yes.
In fact, this itself was a hearing, my lord. Page 92.
This is after compliance of all procedural giving opportunities and all this was passed.
No,
There is a
correct.
dispute regarding hearing, my lord.
But that hearing took place perhaps before this date, not on this date. On the same date.
That one hearing had taken place earlier. But that decision.
But on the same date, my lord, on 24/1/22 was the date of hearing. If you in this regard, a meeting of the students was convened on so and so, wherein Utsav was present. Last sentence of the first para, before deliberation. Where Utsav was present.
Okay. Next para, following the above course of action. A meeting was held on 24/1/2022 by the SDC, wherein the petitioner was present and was given an opportunity of hearing. Stop. However, the SDC recommended termination of his studentship of the petitioner.
Mm.
As per as was recorded in the meeting minutes itself. Then it's
Then
the
page
Senate-
142, my lord.
Senate.
Senate. Page 140 it starts and the operative portion is at 142.
The matter was then placed before the Senate, which considered the same along with other agendas on 11/2/2022. And the Senate as per item 12
12.
of the meeting minutes,
11 February.
decided to accept the recommendation of the SDC. Okay, meeting minutes dated, okay, 11/2/2022. Decided to accept the recommendation of the SDC. Now, that is how the petitioner is once again before the school.
Thereafter, my lord, page 283 order was passed. Page 283 in the writ petition.
Page
283.
No full stop, huh? Continue. Before this court, challenging the consequential order passed on 7/3/2022. Whereby his studentship was terminated with immediate effect. Next para, Mr. K.M. Chaudhary, learned senior counsel, submits that. The respondent authorities have proceeded with the matter on the premise that the criminal court found a prima facie case against the petitioner as was reflected in the order of bail
That was the first senior's order, but that was recall. Subsequent order was passed.
So he submits that there is no such ingredients for pressing criminal charges against the petitioner which can be easily appreciated from the version of the doctor who made medical examination of the junior student who was found to have consumed alcohol along with the petitioner. To stop the petitioner, no doubt, has violated the rules of the institute by consuming alcohol within the campus, and for which he has been sufficiently penalized.
That is not only that, not only for consumption of alcohol, the certain other issues are also there.
His submission.
That-
I'll
Sorry.
record your submission
Not-
also, don't worry.
but-
As he has lost about 3 years. Stop. He also submits that the junior student had since completed her studies and no longer in the institute. Whereas the petitioner has been deprived of his studentship. And thereby leaving him without any future. Stop. He therefore submits that the respondent authorities may be directed to reconsider the case of the petitioner and allow him to complete his studies. Anything else you'd like to add?
That's all.
Mr. Kakoti, learned counsel for the IIT, on the other hand, submits that realizing that the petitioner had not been given adequate opportunity, the respondent authorities themselves had conceded that they will give him opportunity to explain.
Was given an opportunity to explain. He was given an opportunity to explain his conduct.
His conduct. Stop. Therefore, upon giving him all such opportunities, the
23.
What is that?
SDC.
SDC found that his act could not be condoned and recommended that he should be expelled from the institute. Stop. The Senate as well, the Senate upon duly considering the recommendation made by the SDC and after taking into account all aspects of the matter, agreed with the recommendation. Stop. Therefore, no interference on the action taken by the respondent authorities would be required. Yes. Stop. He also admits that the junior student
Yes.
is no longer a student of the institute and had since passed out. Next para. Having heard the learned counsels for the rebel parties, and upon perusal of the materials available on record, it only appears that although a criminal color was given at the initial stage, but as of today, no materials have been placed before this court that the petitioner has been convicted for his action, except that he has been expelled from the institute. Stop. The expulsion obviously has been done in view of the violation of the ordinance and code of conduct of students as prescribed by the institute. The petitioner is said to have consumed alcohol within the campus of the institute, and for such a conduct, he has been expelled. In the midst of his 6th semester, and thereby making him lose his future career prospect. What was the age of this petitioner at that time?
Yes, Mr. Once again.
The affidavit in the writ petition shows that the petitioner was 22 years at
Yes.
the time of filing of the writ petition.
That was in 22.
That is in the year
20.
2022.
So today he's 25.
Stop. Having given my anxious consideration on the issue, I am of the considered view that the ends of justice would be served if the petitioner is given an opportunity to file an appropriate presentation before the respondent authorities, more particularly the Respondent number
Director.
is respondent number. Director is not a party.
I'm sorry, Miller.
Three party number. The full of five lots will book. Raise, turn, huh?
Before the registrar,
Nice.
IIT Guwahati.
Yes.
Within a period of
What, 7 days from today, Miller?
10 days from today.
Yes.
Stop. In the event of filing such a representation, respondent number 5 shall
I think Lordship will say that is the authority. I'm sorry.
shall place
Ah.
the same before the competent authority for due consideration. Stop. Such consideration should be made by taking into account the fact that the petitioner has lost
3 years.
about 3 years now. Three academic years. And being of a young age of about 35 years as on today. Comma. A lenient view in the matter, according to this court, would not be impossible. In taking to such consideration, if the authorities decide that he should be readmitted to the institute, they would be at liberty to seek a bond, appropriate bond from the petitioner, that henceforth he would not indulge himself in any activities which would be in violation of the rules, norms, and ordinance of the institute. Stop. This court is also aware of the fact that the other junior colleague who was said to be with the petitioner has also since graduated from the institute. And therefore, the case of there being clash of interest may not arise. Stop. The respondent authorities shall consider the representation as expeditiously as possible and preferably within a period of
4 weeks, not 4 weeks.
4 weeks from the date of receipt of the representation, along with the certified copy of this order. With the above observation and direction, the writ petition stands disposed of.
Deep level.
Right.
Well, not, can I make one small prayer, Miller? Item number 28, there is urgency, Miller. Can it be fixed on 23rd, Miller? Hey, Ruba. 27, 28.
728. 23rd.
23rd is a Thursday, Miller.
All right.
Yes.
That's the interim order, Miller.
Miller, without any appointment, he is discharging duties as a principal. by virtue of a stay order.
Item 27, 28.
Yes.
List the matter. On 23,
Third, my lord.
23, 10, 2024 as paid for by the learned senior counsel for the petitioner.
Respondent.
I'm for the response.
Sorry, the senior counsel for the respondent, private respondent,
Private.
till the next date, interim order, past trial shall continue.
Deeply. my lord.
Fine. So we'll post it some other time, all these matters. Remaining items, I think we'll have a kindly get in touch with the court master.
24 may kindly be taken day after tomorrow, some urgent matter. 24, madam. Next item. please.
What is considering is the regarding area survey.
Not area, the graduate scale.
Graduate scale.
That will be disposed of.
That GOP is consider again, the director has sent a report regarding the.
Humble
Then
submission.
implications, financial implication report has been submitted before us.
Sometime will be required.
That is
Hmm.
required.
My lord, 71 years old, my lord, some urgency, very serious illness, my lord. So maybe dispose of, my lord, our client has insisting us.
How will it dispose of? How to dispose of? So when instructions being sought, let him obtain instructions. Depending on that, we may accept, we may not accept, and we'll decide. So let it come up
Yeah,
after some time. At least 2 weeks.
Probably positive.
I will not fix a date. Interim will continue, whichever case is there. Interim will continue, and after a week, after 2 weeks, accordingly you adjust. Okay? All the matters.
How like?
Well,